Okay, so a very good afternoon to everyone and a very, very warm welcome to our today's webinar, which is brought to you by Lex Witness, India's first magazine on legal and corporate affairs. We hope everyone is healthy and keeping safe in these difficult times of COVID-19. So please allow me to bring you an all-new world of Lex Witness, virtual, that is www.lexwitnesslive.com, which encapsulates all of our digital initiatives so far across an array of industry sectors and practice areas. Amongst many, the Lex Witness 8th Annual Information Technology Virtual Summit Edition is our debut towards our flagship events moving into the virtual world. After having completed 7 successful editions, the forthcoming edition is scheduled for today and tomorrow, live on your screen. The summit has been one of the most preferred knowledge sharing and networking platforms for the industry professionals ever since its debut edition. Well, before we begin, there are some basic house rules. This is going to be for the question and answers that you can ask. You can ask your questions live at the end of each session. You can use the raise hand icon to join and wait for your turn to ask live questions. And you can also post all your queries in the question and answer box at any time during the session. And if unfortunately there are any questions that we're not able to take, so don't worry, we will address all your questions. They can, I'm sure, be taken up offline with individual panelists, and the entire team at Lex Witness is definitely going to get back to you with answers to your queries if we are not able to take them during the session. So to begin, let me also very quickly run you through the agenda of today's webinar. We are going to start with our first session at 3:30. It's on India's data run. Is it getting too personal? Followed by a focused presentation on arbitration for IT disputes. And thereafter, we have another panel discussion on employment law fevers, Temp check. So to begin, let me first introduce you to our first panel. We have with us, in the first panel, we have with us Mr. Taj Mathew, General Counsel at Honeywell Technology Solutions. He will be moderating the session for us. To very briefly introduce you to Mr. Mathew, he is a corporate lawyer with over 20 years of global experience in technology, covering regions India, Europe, Latin America, in-house experience in US Fortune 100 company, an expert in legal compliance on emerging technologies such as artificial intelligence, machine learning, AI, ML, facial recognition, Internet of Things, unmanned aerial vehicles, drones, software contracts, and open source license management, patents and trademarks, research and development, competitive benchmarking, etc. And the list is really long. We also welcome Mr. Taj Mathew. Thank you for joining us this afternoon. We also have with us Mr. Atul Jubling, General Counsel, Compliance Officer, and CS at India and South Africa at Schindler India. We welcome you, Mr. Jubling. He's currently employed with Schindler India Private Limited as a General Counsel, Compliance Officer, and Company Secretary, India and South Asia. Atul comes with over 30 plus years of experience, which includes working with a premier public sector bank, Bank of India, any NBFC and merchant banker, the Tata Group Manufacturing and Export House, Tata International Limited, US MNC Otis Elevator, HDFC Life Insurance Company, and Godrej Agrovit Limited. Then we also have, as a part of this afternoon's panel, Ms. Deepalakshmi Vadivelan, who is a General Counsel, India and APAC at Kescorp. Deepalakshmi works for Kescorp Limited, handling the legal function, advising multiple business verticals and the management on legal issues, working out the legal strategy for complex commercial transactions, amicably resolve commercial disputes, and extensive experience in managing litigations. She has diverse experience in cross-border transactions involving APAC, Americas and Europe, strategic global alliances, M&A activities, compliance on data protection, legal compliance training, employment laws, contract management, and work related to intellectual property. And she's also been, in fact, a judge for the National Moot Court Competition in reputed Law College, Bangalore. We are also being joined in this session by Sonal Basu, General Counsel at Mindtree. And Sonal, as I said, is a General Counsel at Mindtree, where she provides strategic advice on PC, FCPA, GDPR, immigration compliances, M&A, government relations, as well as diversity and inclusion initiatives. She also advises on employment issues and helps the management in making strategic determinations on pre-litigation and litigation matters. And Sonal brings with her vast negotiation experience with global customers and has a really rich experience in handling multi-million IT deals and strategic global alliances. She has also focused on telecom as a practice area and has represented a host of telecom companies on DOT and TRI regulations, and has been a faculty of the seminar course on cloud computing at the National Law School, Bangalore, and also a guest speaker at IIM Bangalore. With that, I'm going to hand it over to Mr. Matthew, who's a session moderator, to take this session forward. Thank you.
Samriddhi, thank you. And good afternoon, all of you, and a warm welcome on behalf of this esteemed panel to this Witness 8th Annual IT Legal Summit. I'm really glad and honored to moderate this very important session, which I believe, which I assume it will be very relevant to all of us. And one thing all four of us are aligned yesterday before we walk into this session was that we will not make it look like a classroom talk. We'll try to make it very relevant to what we have been doing it here, so that those who are part of this session, you also are able to connect to this. Quickly, again, the theme is data, personal data, and maybe a bit of general data as well. I've been with Honeywell for the last 11 years, and in the last 7-8 years with an engineering arm of Honeywell. Honeywell is not an IT company. It's an engineering product company. We have products starting from aerospace engines all the way up to refinery processes and safety PPE kits like N95 mask or anything. So it's an engineering company with wide. But in my last 7 to 8 years, very specifically when I've been working with this engineering firm, I've really seen the transition from a product company into a software and data-driven company. So now we have multiple products. Let me give you one example before we jump into the panel. During COVID, we introduced a product which is a camera-based one, which will tell when an employee or when somebody is walking into the building, it will scan. It will tell the temperature, the body temperature of that person, and it can also see whether that person is wearing a mask or not, so that immediate action can be taken. So no more standing in the queue and measuring the temperature or security calling out all those things. So you can imagine the kind of data which was there. There is facial recognition, and again, you have to measure the temperature to come out with the right algorithm to come out with this product. So there is a lot of medical related data which were actually taken. Again, the data, most of our Indian engineers from Bangalore only was working on this. Still, there was a bit of US folks working on it. So there is question of data transmitting from India to the US. So you imagine anything related to the private personal data, a lot of things were there. So a company like Honeywell, which traditionally is an engineering company, we had to deal with a lot of things. So I was wondering from a software world, real software world, when you guys only deal with data and how important and how large these will be. With this introduction, guys, let me get on to the question to my esteemed panels here. Atul, probably I'll have this first question to you, right? All of us have been hearing about personal data protection. The bill is there. It'll become an act today, tomorrow, or yesterday, today again. But we never know when it is going to come. So what's the latest on this, Atul? And if I may add one more question to that, what's your suggestion on to those in the group on what we should continue to do until the new statute comes into place?
Thank you, Taj. You asked me a first question only, and it's $1 million question: when PDP will become act. So as per because we all are awaiting because we are geared up based on the GDPR. Majority of us are geared up on GDPR as a best regulation. Uh, PDP bill, as per the information available in the public domain, it will be taken in the budget session. So it has gone to first quarter of 2021. So that is the update, but it can come up anytime because particularly the issues and concerns have been addressed, and I don't think there are major concerns left out in the bill where there will be some more discussion will happen. So I feel that fairly it will come in the first quarter of 2021. About the current applicable regime, as you mentioned that we will not make it a legal session, but there are two parts to the compliances. One part is the companies where GDPR is particularly they are prone to GDPR. Mainly those who sell good and services to the EU citizens, they have to comply with the GDPR even currently. Uh, Balance companies, I will say the act was there from 2011 rules, SPDI rules under IT Act. IT Act came in 2002, but 2011 rules are there where the sensitive personal data information has to be protected. But if I have to talk about the privacy in India, still it is not taken to that extent where the seriousness is there. I can explain also. Let us go back to the somewhat of history, and in past court have not recognized the privacy as a absolute right. They have recognized the right, but it was a regulated right. 2011 SPDI people considered, normally it was applicable to all the companies, but under the myth that it is applicable to only data processing and IT companies. I don't think majority companies, I will not say IT companies or data processing, but as you rightly mentioned in the beginning, that manufacturing companies, I don't think they have taken seriously that compliance. I can give you the example of 2011, and then sorry. So IT Act is applicable. IT rules or SPDI rules are applicable from 2011. 2017, we started discussing privacy as a serious subject. Till that is August 17, Puttu Swami judgment brought that privacy as a constitutional right for Indian citizens. But in between, Banking Regulation Act, RBI regulated banking transactions under the particularly SPDI. Similarly, insurance bills, insurance IRDA regulated the personal data about the policyholders. Most important, companies also have the rules for the privacy compliance. I can touch upon one case without quoting the details. 2012, one bank paid 15 lakh compensation for sharing the credit card information of husband to wife. So it is taken up seriously, particularly for the SPDI, sensitive personal data information, and which mainly focuses on the financial and health data. So health data also, there are good number of examples about the penalties. 2017 we started seriously looking at everybody because there was a GDPR later on in 2018 made compulsory. So privacy started, we started discussing privacy, but still I feel that there is a lot of awareness is required. I can give simple examples of privacy violations in a routine life, that on the WhatsApp we forward somebody XYZ is COVID positive. That's a privacy violation. It's a simple thing and without checking the data itself. So this is a common violation which people do on the privacy. So still lot of awareness is required in the general public. On the corporate side, I will say we will have to be careful, particularly once the data comes in the picture. When now take current example of work from home, attendance is marked on the mobile, so your location is tracked. Sometimes it is after office hours also. We are putting that I am closing now at 8 o'clock, and then location is tracked. So that's again that again goes into the privacy mode. So this is what actually the current regime, to sum up that Some companies have to comply with the GDPR. Some companies will have to comply with the IT. Some or maybe majority companies will have to comply with the SPDI rules. And the regulators are very watchful in bank, BFSI sector as well as tele sectors, telegraphy.
Okay, thank you.
Yeah.
Thank you, Atul. Yeah, helpful. Deepa, if I may move on to you with my next question. Again, it's nothing new on that, on the data localization per se. From your experience, Deepa, could you please share some of the cases or some difficult situation that you had to deal, right? When the big question on data localization came in, and how did you handle those, and which you think might be helpful for the audience as well?
Thanks, Taj. Good afternoon, everyone. Thanks to Lex Witness and team for giving us the opportunity. See, after the discussion on Aadhaar, the hotly debated topic, if you consider, I think that's a data localization as part of Sri Krishna's committee or the subsequent BDPB bills, either in 2018 or 19. And if you took consider the Sri Krishna's committee and an 18 bill, it was very, very strict data localization process was recommended. Even personal data cannot be transferred outside India. So I think that's where the strong opposition from the industry circles, including NASCOM and industry associations, were raised. I think now in 2019 bill, it is slightly to be transferred. Only the sensitive personal data or the critical personal data, there are certain reservations keeping a copy. And critical data, definitely it cannot be transferred unless there are exception scenarios like healthcare, health-related issues. I quickly would like to respond this in two parts, thoughts. One, as a corporate citizen, where we are all wearing the hat of a business, enablers, and how we are working as a fraternity. The second, as a natural person, as being an Indian citizen, I just would like to share some views. Okay, that would help us out to understand how it is having an impact on it. Firstly, as an accountable corporate citizen, my primary objective is to ensure the cost effectiveness and the enabling the business globalization. That's where every person works on that. Some of the arguments and practical challenges, which as you rightly pointed out, which we are going against the data localization is, this is in principle against the philosophy of internet, right? Or a cloud services or cloud computing concepts, or the globalization itself is a concept that lasts a decade, more than a decade. We've been all trying to put it across. The organization has to get into globalization. I think this will completely become a trade barrier for that angle. And next is the liberal economy. When we are talking, when we confine to a domestic market and other aspects, I think there it will be an impact for us. When it comes to a transaction standpoint, I think maybe we all will agree and appreciate on that. The global service providers, if we take even a cloud service provider, I think comparatively, they have the cheaper prices. If you honestly ask me, when we get into the transactions, right? And secondly, the technology advancement, which they have it as in one-stop solutions for enhancement or decreasing within the quick SLA turnarounds, I think I go with the global service providers. Though there have been discussions on security and safety with respect to data flow, I am not definitely advocating that angle. I think India has been, I think, far ahead on that aspect. So that's the difference. The second part, if I come to a citizen of India, the natural person, I think it's a basic expectation from every individual citizen is that the nation has to support or protect the privacy rights of an individual. It be every right, including a privacy right, as Atul rightly pointed out through this recent judgment. And the citizen data should not be misused. These are all the primary objects we always expect under the data privacy right. If I go with the data localization debate, there is a new concept got emerged in the system, which is a data sovereignty. Thereby, the nations or the government also mandates that we need to have a control over my Indian data or the citizens' data, which gets generated in India. I think this is the two parallel concepts have been emerged recently in India in the last 3 to 4 years, if you look at it, right? So though we've been arguing data localization is going to be the trade barrier, all those aspects, some of the other opportunities which I would like to put it across for all of us is, we will definitely agree that one, it will increase our digital infrastructure. The second is, when India goes for the startups or digital India, all this kind of a concept will be promoted through a cashless economy. And it creates a job market, employment opportunity for many of the resources in India, right? So that's the other angle which I would like to put it across. As a legal fraternity, I definitely advocate to go on the handling protection of the cyber crimes. That's a major challenge in one of the major crises or a concern which we constantly raising under against the existing data protection regime of IT actors. It does not have the effective law enforcement agencies, or fail to handle the jurisdictional cross-border related cyber crimes. I think if you have the data available domestically where you allow the authorities to access that, which subject to if and buts are there, that's secondary. But that will really help us to overcome these kind of challenges. See, other aspects where I'm looking at it, if you take it even in US, the federal agencies mandates to store the data locally, or be it Germany, Australia. In that case, even a GDPR, Europe also mandates us to look at the adequacy status of the country when we try to transfer the data. Probably we can discuss that in detail. So keeping all this one side, I also strongly recommend with the reasonable restriction, the localization is recommended. The other aspects is, if you recently look at it, either be it an e-commerce policy or payment policy or digital payment policy, or the recent non-personal data report, which is recommended by the Krish Gopalakrishna committee, I think all this mandates to have the data localization process. It's very clear now. Maybe the nations or the committee has to really maintain the balance between the individual's right versus the expectation of the corporate citizen to handle and manage these data. Maybe looking forward, let's await, as Atul said, maybe the next quarter even we are expecting. Hopefully that should give us the better clarity for all of us.
Super. Thank you, Deepa. Helpful. Sonal, again, those in the call, there are a lot of issues. We can keep on talking about many issues for 1 hour or even one day, but we are trying to just focus on 2 or 3 key aspects. So the next one, Sonal, to you, is basically on the latest European Union, that Court of Justice order of July 2020, right, which invalidated the EU-US Privacy Shield framework. What does it really mean for India and maybe companies like us, or maybe the rest of the world? Yeah.
Thank you, Taj, and good afternoon, all. Am I audible?
Yes.
All right. Okay, so it's a very topical topic these days, the Sherm's discussion, right? Because it has kind of unsettled the privacy shield which was existing. It did achieve the adequacy status between the US Department of Commerce and the EU Commission vis-a-vis transfer of personal data between these two countries, companies operating in these two countries, to support the transatlantic commercial transactions, right? Now, given that it has been invalidated somewhere in July of this year, there are only a few options which are left with companies. A is to ensure that whether you have the adequacy status. B is if you have a BCR in place, binding corporate rules in place, which is a very comprehensive framework. So if you do have BCR framework in place, then you don't have to worry about the SCCs, the standard contractual clauses. But if you do not have the BCR framework in place, then you need to ensure that you align yourself with the standard contractual clauses, because that would capture the way data would be transferred between your companies across these nations with adequate technical and org measures and adequate privacy framework and the governance in place. And the last bit, of course, is if you have an explicit consent from the data subject to transfer the data. So I think there's a lot of work which has now been created for the organizations to ensure that they fall under either of these tracks, which I just explained, so that they are compliant. Otherwise, there would be a major compliance issue vis-a-vis these companies.
So if I put it this way, Sonal, the business will still continue to do, right? It's all about the nitty-gritties of compliance requirements have probably tightened.
Absolutely. Absolutely. Yeah. And I think one needs to note that, and especially, the privacy officer or the department who is the legal department or the privacy office who is handling these matters in companies should ensure that you do have one of these in place, either a BCR or SCCs, because otherwise there'll be a major gap and you cannot live with that gap because it's a major non-compliance.
Yeah. All right. Thank you. So yeah, moving on with our theme again. See, again, a little bit of Honeywell, because when I'm in here, I have to market Honeywell. No? Otherwise, I do not justify my 60 minutes coming here. So one thing which I can tell all of you that we all will be flying in a I would say, unmanned taxi in our lifetime. It's not going to be a Hollywood movie thing or something. So, and Honeywell is already partnering with someone. So maybe we are expecting as early as 2023 at some part of the world, there will be a real flying. It's all happening or made possible through data. So it's again, there is no pilot. So it's all about a lot of artificial intelligence, a lot of learning. The machines learns from the system then and there. It see the obstacles on while flying, and it adjusts the path. So all those brain and engineering intelligence, the system need to really happen. There is already an Amazon, and now latest is even Walmart. They already got the permission from US FAA to deliver their things through this. When the moment human being comes, it's all about the security aspect, which is really becoming. Otherwise, the technology per se is readily available. It takes the payload, it flies, it locates the GPS, it can land there, give it, and then come back. So the technology per se is available. It's all about the technology and this one. So here, why I brought this specific case here is because in these kind of thing, it's not about the personal data which we are talking about. It's about general data, but tons and tons of data, absolutely tons and tons of data, which probably we might be acquiring some data from Google because they are sitting on it. When we talk about a large refinery, factory refinery, which spread across hundreds of kilometers. So there again, we will be collecting large amount of data from the owner of the refinery. So it's not just about the personal data when it comes to doing business, especially in the industrial world where I live. So yesterday when those in the call, folks, yesterday when we were collecting, Deepa was bringing this up, that there is the Chris Gopalakrishnan committee report. We heard about it, but we never delved into it in detail. But Deepa was sharing some very interesting experience and insights into the Chris Gopalakrishnan recommendations, basically, that committee recommendations on non-personal data related one. So Deepa, for a minute, you can assume that those in the all in this group are like school students. So why don't you just give us some basics Gyan on what it is and what is it that we can look out for?
Thanks, Taj. It's really a very interesting question and topic. Am I audible? Can I switch off the video to ensure?
I mean, you may want to try that, Deepa, once. Yeah.
Probably just raise your hand so that I'll switch off the video if there isn't any issues on the bandwidth. Okay, hopefully it should not. As we said that today you all have been looking at, there are a lot of investments also happens in India, right? So from a legal standpoint, I think we should not really look at it. There is just an investment which is happening, but there are a lot of rationale behind these investments which is coming into India, especially that biggies like Facebook or Google investing in, for example, on the Reliance. So probably I'll just give this background as Taj stated. so that will help us out really why, how critical this is. Definitely, this itself is a different contours which requires a 2 to 3 hours of session. But let me try to broadly cover up the salient features of this in next 5 minutes. So this is again how this is getting generated. Data is getting generated as part of Sri Krishna's committee report, or if you refer section 91 of PDPP bill, it very clearly he recommended to have these separate non-personal data regulations to regulate these non-personal data and community data. Though he has defined the community data, but it couldn't address it come under the framework of a PDPP bill. So the government appointed this Krish Gopalakrishna committee, the 7 members committee in 2019 to regulate or come up with the framework for this non-personal data and community data. I think recently, July sometime 2020, the report got published for public comments. Krish Gopalakrishna is the co-founder of Infosys, one of the co-founder of Infosys. Okay, broadly, this report proposes the regulation of non-personal data with the primary ground and object is economic and social value of the data should not be within the monopoly of the company. It should be distributed to all the entities or including the startups. There should be a level playing should be there. That's to encourage that. I think India has proposed this or focused on this committee. I think it is very well captured in this committee's report, broadly addressing these points. It's very, very, very nascent stage, and it will definitely go through a lot of iteration. If you look at it, PDPP in the last more than 4 to 5 years, we are all talking, and definitely this will also take an equal time of it. On high level, some of the pointers which it defines is non-personal data. It means any data which is residue of personal data, or anonymization of the personal data is considered as a non-personal data. And it broadly classified, as we have been knowing, that general non-personal data, sensitive non-personal data, critical non-personal data. Again here, the general personal data is permitted to be transferred, and sensitive and critical non-personal data cannot be transferred without having serving a copy, or again, the national interest or all this will come in place. And secondly, here, the primary point which this committee addressed is the ownership of the data, which is on public data, private data, and community data. I think the public data is very clear. Any data collected by government is public data. Private data, anyone other than government who collects it is a private data. Here, the major point, how this private data, which is going to help us to monetize or create a level playing for these startups. The reason is government has the right to push the organization to put the data in public when the organization exceeds the threshold. Right now, the threshold is not defined. For a companies like Google or Amazon or a Flipkart, if they maintain the data, if there is a threshold being fixed, the rest of the non-personal data has to come into the system. I think a lot of big companies themselves are lobbying for this data, not only the startups. So that's the one of the major advantage of this entire report. And another, some of the key part which is addressed in this reports are the concept of data business is defined. The concept of data businesses, for example, as rightly Taj pointed out, Honeywell is creating a lot of business data as part of his engineering process or IoT equipments, right? Along with it, the data which gets generated, he can set up a new business vertical or function called data business, where he is allowed to sell or monetize that, however form, whether you can be a custodian or you want to give it to someone else as an aggregator. I think that's purely, which is yet to be evolved, but this concept has been identified and introduced in this bill. So that's one. For example, how many of us, today it is happening, I don't know, how many of us realize that in an organization, there are an HR employee related benefits mailers comes. For example, Amazon or Flipkart's, you click on as an employee, you will get a 10% discount, right? If you honestly ask me, it's not only an employee benefit without sharing and personal data from the organization. Based on the employee base where you are having, these kind of big organization, the e-com players are giving a percentage or a commissions to the organization. It can be nominal. I'm not saying it's 1%, 2% of the transaction value, but this leads to when data generates the money for it or a business for it. Think about an organization like us as a Quest, 3,80,000 employee base only in Pan India, right? Even if it's a 1 rupee or 1% of it, I get out of 1,000 rupees, you can imagine that, right? So that's one concept which is there. The next one, another point here also, some of the roles are defined: data principal, data custodian, data trust, and data trustees. If you could correlate some of the concerns raised in the PDPB, the concept introduced as an consent managers, or who will be the trustee, trust score, I think those are all yet to be addressed. Maybe if this legislation comes, maybe this can correlate with those kind of issues and address that. Another major one point which is here is that, again, data protection authority will be appointed. It's not a DPO. Here he is called as a non-personal data protection authority. It mandates this regulatory body to regulate this and ensure that enforcement happens as per this legislation. And another one role, I think, am I audible? Is it fine, Taj?
Yeah, go ahead. It's
great,
good.
great. So another one point where we all need to look at it is, this regulation is considered as a data governance regulations. So there may be an officer who's expected, it may come definitely. Right now, this is not precise, but there is an hint, it is given in this entire report. There may be an officer called data governance officer in an organization whose role is primarily focusing on commercial exploitation of the data which is available within your business, and how can we extract the financial benefit out of this. So it's just like in regulating the data market, which will be given to the market so that the market players will determine the price for your data. So what data you will maintain, whether it is a location, for example, if a L&T takes the non-personal data of a vehicle movement from Tamil Nadu to Karnataka, I think that data will be given in the market. So you have the right. Probably tomorrow the manufacturing industry can decide, or the similar infrastructure organization can fix the price for the data and they can pick it up. That's what we are expecting or envisaging under this. The another one aspect which I would like to now clearly state, that is why the huge investments which is coming around this entire system, and what's the logic behind it is, one, in every law, if you look at it, maybe as I said earlier, e-com policy or cloud computing or this non-personal data, or even a privacy bill, it mandates the data localization and data sovereignty principle. And the second aspect is, it is also looking for startup companies. There are a lot of benefits and advantage which is available to the companies. And the third is, India is one of the major data contributor. If we've been studying in a lot of statistics, right? 18 to 20% of a data where the non-personal data, the option is always available out of India compared to all other countries. I think that's where we look at it. This is a very, very potential opportunity for all the biggies who are lobbying behind India or doing investment behind India.
Good. Very interesting situation, Deepa. Very interesting. Yeah.
Okay. So one point, Taj. I think we've been saying that, right? India is lagging on the data protection bill. I think this is a one bill. The outcome of this bill, the entire data, the gamut of data will be regulated either under the personal data protection bill or non-personal data protection bill. And if it comes to non-protection data protection bill, right, India will be the trendsetter and well ahead of the curve of other organization. Even the developed organizations like, or countries like your Europe or Germany is struggling how to regulate this non-personal data. I think we'll be well ahead, and we will be the trendsetter, as I said, will be there to under the concept to relate data as oil, and that would lead the next generations. I think that's where we are looking forward for India now.
No, very interesting. Yeah, because so far now we have been only thinking about contractually controlling, getting the rights on data. Now it's all about something more than that. There is a
yeah, now you have another
about.
opportunity to go back to business on this non-personal data.
Absolutely, absolutely. Interesting. There are some questions come in between. Probably we may be going back and forth a little bit, but guys, forgive me, but there are some probably interesting questions. Sonal, there is one query from Sanjay Kumar. Are US companies subject to GDPR rule?
I'm sorry, Taj, Mr. Kumar wants to take this question live. Can I bring him on screen, please?
Yeah, please.
Mr. Sanjay Kumar, you're now live. Can you please unmute yourself and ask your question live? Mr. Sanjay Kumar.
Hi. As you said, this US data privacy, ESU data privacy shields is now broken. So what's like current status? Are the US companies are subject to GDPR and how they are managing their personal data?
Okay, that's an interesting question, Mr. Kumar. So a couple of things. In the US, the local companies are already governed by sectoral laws, right? Secondly, there are laws emerging on the privacy front in US already. If you look at CCPA, it's already gone live. Of course, it's partially enacted and it's going live fully next year. So there are already existing laws which govern personal data. And there is also HIPAA for health related data. That's one. Secondly, if US is processing EU data, then definitely US companies would need to be compliant with the data protection norms. And they would need to ensure that they have appropriate documentation in place, given that the privacy shield has been invalidated. And I gave some examples of how you could protect yourself, right? One is if you have DCR, then that's good enough. That's a comprehensive framework. If not, then you need to have SCCs in place.
Sonal, thank you. Sonal, anyway, you're there, so let me stay with you on another question, right? The entire the legislation gamut under which now we are going to play. See, in the short term, we have this IT Act and SPDI that rules are there. Then in the medium, the PDP, anytime it will become act. So the latest prediction from Atul is that Q1 2020 will have a statute finally. Let's yeah, hope for it. Then there is Deepa bringing this bomb, larger bomb. I know that we have a non-personal data is going to be regulated maybe in the not so near future. So how this entire system is going to be, again, we have from law college, we have studied 36 items and 150 laws. So nothing rocket science for us. But coming to this data, and which is so important for our livelihood, especially for the young guys who are coming out, they probably only would be dealing with such things other than incompetent certificate and registrations and stamp duty, all those things, right? So how do you see this entire regime is going to be tomorrow?
Yeah, so I think it's a very interesting move, and I'm glad that we are already in the GDPR regime, because now if you look at the shift, there's going to be a cultural shift in protecting personal information, right? Which was not the case, as Atul rightly mentioned. Even companies, some companies in certain sectors were not taking the protection element seriously. So I think there's going to be a major cultural shift, and of course there's going to be this legal mandate of the legislation which will be sitting on the corporate's head. So the accountability on companies is going to increase. That's another thing. So it's a positive move vis-a-vis all this legislation. So of course, if you have comprehensive GDPR framework in place, that's the best thing that you could start with. And of course, when PDP gets enacted, it has more stringent norms, in comparison to GDPR, because it also imposes some criminal liabilities for a minor category of non-compliances. So you will have additional compliances beyond GDPR once PDP is live. And when the NPD comes into picture, I believe there would be a global robust global privacy framework within India, which would govern all sets of data, be it financial data, be it your minor data, be it your non-personal data. So there will be a global robust framework in place for in our country, which would give a competitive advantage to us, doing business. And we could also explore a lot of innovation, as Deepa rightly mentioned, leveraging data as the oil, and giving that edge to a lot of companies such as CPG companies to actually leverage the data patterns and to monetize or commercialize the NPD. So to answer your question, Taj, it's a positive move. Of course, it increases a lot of accountability on corporates. And I would say start your work. Don't wait for PDP to get enacted. Focus on GDPR framework. Ensure that you have all the policies and procedures in place. So you're prepared for PDP, for the enhanced compliances. And then, of course, you will also be having a framework to deal with NPD when it comes into play. A lot of work, I would say, for lawyers and others concerned.
That's good news. Yeah, more work, it's better for us.
Lawyers are going to enjoy.
Absolutely.
We are going to have a good time. There are a couple of questions again coming, very interesting ones. So, Akshay, do you want to bring up Sanjay Kumar next if he is okay? Otherwise, I can read out the question. Atul, probably it will be appropriate for you to take it up if it's okay.
Before Atul does, I just would like to add one point to Sonal's.
Please.
It's good that organization, while they start adhering to the compliance requirement of PDP, at times the data segregation happens, right? So they know that the value of non-personal data, how that can be commercialized. So the mechanism for the data segregation will be at the right point in time for India, I believe, and it has given that indication. So maybe as a lawyer fraternity, we have to create that awareness also in the system.
Oh, beautiful. Yeah. Thanks to Lex Witness, I became more aware on the non-personal data. And thank you to you as well. I will take that. There is a question from Sanjay Kumar. Atul, it reads like this. We have privacy laws in place under IT Act. How new data protection is different from the existing privacy laws?
So, yes, to answer quickly, under Data Protection Act, which is a data protection bill, the penalties are heavy. So you will be interested to take in fight. Today, suppose somebody calls you, there is a trial regulation that unknown calls can be objected. But the penalty is just 25,000 to the company, and that number gets particularly deactivated. So nobody is interested in 25,000. But PDP, once it becomes, it will give you an option up to go to 20-25 lakhs, and everybody is interested in looking at this privacy violation. So simply, see, IT Act, as they particularly have limited operation because of the awareness, I will say. It is not because that IT Act is fault. Because IT Act says that whoever uses the laptop or internet, they are liable to comply with the IT Act. So accordingly, privacy has to be maintained by all the companies. That I don't think any company is working without laptop or internet, right? So the new act will bring in more detail about the compliances, and certain rights which are there under IT Act will be further elaborated. So it will be a comprehensive legislation for the compliance.
Excellent.
Yeah, to add on to Atul's point, Sanjay, couple of different, see, if you honestly ask me, I feel that existing data protection regime, which is in section 43A and rule 2011 are quite interesting, and it is fine. A couple of observations, what we have seen, we would have done an amendment to the existing IT Act itself, though the object is slightly different, because the IT Act object is to take care of an e-commerce business, not to address the data protection. But however, I don't completely say that it's not absolutely taking care. If you look at the rule 3 of 2011, right, it absolutely captured your 8 principles, which is your purpose, consent, notice. I think everything, OECD 8 principles are taken care. The only disadvantage or interpretation of a lawyer fraternity like us, we have done that it is applicable because the 43A says personal data, rules talks about sensitive personal data. We have just taken that leverage under that. As I stated in earlier point, there is a lack of enforcement agencies here. Though we have adjudicator tribunals, it's only a handful of cases. And that also, other than Mumbai and Chennai, I have not seen any progress on those kind of cases which got filed. These are all the couple of things I felt that which made us to get into this new bill. Otherwise, the current one, it's a well taken care. As an organization, we all as a corporate needs to adhere to it. Yes, it has not taken care of government. I completely agree. But otherwise, the private entities, we can go with the existing data protection regime to work on our privacy related all points and concerns.
All right, thank you. This is very interesting, guys. Again, a quick time check. We have maybe 10 more minutes left. At least we should give 5 minutes to the audience to ask live questions, because there are many questions coming here. If there are live questions, we'll take few of those. Otherwise, there are already questions. So last 5 minutes, maybe one question, anyone can pick it, Atul or anyone else in the room. See, when we talk about any presentation on data privacy, it's not complete without we touch based on GDPR. But again, I don't want, like we mentioned in the beginning, it should not be academic. Anything that you guys want to share from the experience on what the distinction between our laws and GDPR, or anything interesting on GDPR?
If I have to say only one or two points. One is the Indian PDP bill is customized to Indian circumstances, so the breach notification timing is not there. That's one major thing which I can say. And others, under GDPR and other laws also, there is a 72 hours notification. Secondly, data principal notification is also not compulsory. It depends on the authorities to decide. Second is right to erasure is not specifically mentioned. It is right to be forgotten. Right to erasure is not specifically mentioned. Third point, if I have to say one practical point of view, I'm talking about the child age is 18 under PDP, whereas in GDPR or other countries, it is 16. Somewhere it is 14 also, depending on the state's laws. So these are the three. Deepa has raised the hand, so she can also add.
Pretty much covered, Deepa. Anything else? Okay. Anyway, you're on mute. Okay, I've seen you. Go ahead, Sonal.
Yeah, one broader right which PDP gives is to, right to audit, which is quite a broad right, which is also going to cause a lot of, additional compliances on the organizations vis-a-vis access.
Okay, that's interesting. So thank you. So let me go back to some of the questions. So Samriddhi or Akshay, do you want to bring?
Raj, we have quite a few questions in the Q&A box. I think
okay.
You can address them.
Are you planning to bring them online, or should I pick?
You can read the questions, Taj, and take them up.
Okay, sure.
Yeah.
So there is one question from Hem Chandra. Sorry. How does the privacy regulate data transfers that may take place through WhatsApp, Facebook, etc.? I think this was touched upon earlier, right? There was another question. Give me a second. Yeah, one question from Lakshmi Nayak in the beginning. When we talk about data localization, on one side, how do we ensure that localization when MNC is interesting, whose server is placed outside India, or a parent company maintains the information, like employee details, etc. So how do that localization piece taken care? So this is a question from Lakshmi Nayak. Yeah.
It's a very interesting question, Lakshmi. I think this is something that everyone goes through it, right? In a PDPP bill at this point in time, there are exceptions which are given under section 41, 40 and 41 that clarifies this. If there is an intercompany, you are permitted. You will have an intercompany arrangements and agreement, you will take care. So, right, that is permitted. It's the transfer, which is an outside the organization, there are a lot of restrictions imposed. Maybe we have to wait and watch what this joint parliament committee is going to come up. I think that's where there is another set of debate which is all on. They are inviting the cab aggregators or Amazon or Twitter. You have been seeing that last 10 days, right? So I think we expect that there are a kind of and some checks and balances they are trying to bring it on. I don't see a challenge in transferring the data between an intercompanies.
Okay, good. So there is another question here from Milind. During the current lockdown, the data breach, especially financial theft, has increased by leaps and bounds. Do you think the current IT law and the future data protection regulation will provide faster relief to aggrieved party? So this is a question from Milind Kulabkar. Yeah. Anyway, India is known for our very notorious on judicial process. So distinguishing this alone from the overall that notorious piece, I really doubt how it would be happening. However, Deepa or Sonal, do you have any insights on how this the regulator is looking very specific to handling the data related aspects? And Deepa, you already mentioned there is something in Chennai, in Bangalore, but it's not a full-fledged per se, right?
Yes,
You also would be dealing a lot on that. Yeah.
Yeah, the existing one may not be helpful to handle this crisis. We absolutely agree. There is no denial. But we look at it, right, as we were discussing even the PDPP bill, there is a different data protection authority, and under the authority there is a commission going to be set up, which again still yet to be decided, right? There is a central government along with the data protection authority is going to set whether it is the state-wise or national-wise the commission which will be set up to handle this. But we are looking for, and why we are coming to PDPP bill, which may be repetitive from my end, that lack of enforcement issues, I think we are coming up with this bill. I definitely government will take care that will be addressed. And second, even if it is a non-personal data, again, there will be a non-personal data protection authority is going to come who will take care of all this. So hopefully we have to wait and watch. We are in the nascent stage, but still, however, the journey has started. So.
Yeah, and I think there would be better governance with the DPA in place, with the commission in place. So of course, there would be a lot of focus in addressing these issues in an expeditious manner, but we need to wait and watch how everything is going to pan out in terms of, the setup. Until then, I don't think we would be in a position to comment, but yes, once there's a framework in place, it would get a lot of focus and attention in terms of redressal.
I would like to add here, actually, Deepa, you mentioned that the data protection as well as cyber security goes hand in hand. And on cyber security, I can tell you that there are a good number of cases where it depends on how much serious and crucial case it is. Otherwise, the current authorities also have the capability to do the justice. So it will not be to all the cases. Whereas we all know the cases where bank money has been taken out in crores and it was recovered within 3 days. So if authorities take interest, they will be able to do it. So it depends on the severity of the sin as well as crime. So yes, I agree with you. The current regime is not that particularly supporting, but if they want to, they will be able to. So it depends on the severity of the violation.
Okay, so I think we have 2 more minutes left. I don't want to overrun, definitely. That's the last thing our audience would be wanting. One last question from Ramesh Kumar. Do you think that existing technological and legal framework, both, so technology framework as well as legal framework, is sufficient in India to protect and regulate various kind of data as public, private, and community?
So,
yeah, go ahead.
Sorry, yeah. So the PDP does talk about a very broad DPI compliance, right? And hence there would be a lot of focus in addressing the technology part because DPI will focus on the operational nuances. But in terms of having a robust legislative process, yes, we need to wait and watch. There's a lot of traction in this space, but I'm happy that we do have GDPR framework, and which has already started governing the handling of personal data in a robust manner. So I think once the PDP comes into play, the collective set of legislations will definitely enhance the compliance levels.
Yeah, absolutely. Go ahead, Atul. You're on mute, Atul. You have to unmute yourself, please.
Sorry. I will add only one thing, that we are expecting everything from the regulatory authorities. But the problem is that as a data subject or data principal, we have to be also aware when we give the data. So data protection will be possible if we are also aware how to use our ATM cards, how to use our data. We give the data as it is. For example, when we visit a site, there is a forced consent and we give the data. One more thing I would like to particularly say is that whenever you get anything free, your privacy is compromised. And then we cannot blame to the government that, oh, there is no, because you have to understand one thing, with our population and number of authorities, it's totally mismatched. Further, the creative violators. So whatever protection you have, there will be some kind of violation. So one has to be aware about our own usage of our own data. Wherever now giving the visiting card also will be parting with your personal data, address and number. So you have to see that. So I think some Samruddhi has come. So I will stop.
So thank you, Atul. Yeah, and just one point on that, guys. And there is an ISO standard on the technical side, so that is there. Plus the business continuity, each organization would have worked on something. So those are I would say something on the technical side as well. So which I'm sure all of you should be aware. With that, okay, last.
So in simple form, in simple form, it is very difficult to put the technology and legal in a framework. But as a fraternity, we definitely have the obligation to create the awareness to the organization, public, as well as to the ecosystem. And a corporate person, what I suggest, any data comes in simple form. First, classify the data into personal and sensitive, as well as into non-personal. The moment it reaches a system, have a process of encryption or anonymization. When the data goes out, the anonymized encrypted data goes. I'm not a technical person, but this helps you how to end-to-end ensure compliance and governance. If you want to ask us in a 1-minute answer. Thank you. Taj, I think I need to really appreciate you. It's a well-moderated session, and you bundle the multiple questions into one question with us and extracted it. Thanks a lot.
Taj, I have a live question request. If you allow me, can I?
Do we have time to take it? Actually, please go ahead. If you
yes, please. 1 second.
We are all good. So only one question I had is, now it's 4:30, right? So I have 2 boys at home. So normally after around 4:30, the situation at my home is like a Bahubali movie climax scene. I was really hoping that these guys do not break the door and come into the room. So right now, anything goes wrong, go after this. Actually, it's on you. Please take.
No problem, Taj. No problem. Most welcome. Ms. Dharti Shah, can you please ask your question live?
Yeah. Actually, ma'am and sir, I have one question regarding the cryptography. As you said about the encryption, decryption, but there are hackers and such kind of people who hacks the private key and public key as well. So how to protect that kind of data?
Dharti, to answer your question, I think in non-personal data, the recent report, if you look at it, the process of anonymization and encryption has been clearly captured. I'm really sorry. I'm not giving the direct answer to you because it's a pure technical one, but I have seen a lot of technical terminologies where used. I think maybe you should please refer that if you get an opportunity to examine. And any point data, this one point I missed it out. I think this one, can you hear me? Am I audible?
Yeah, go ahead.
Great. This one point, actually, I missed it out to cover as part of non-personal data by features. I think she has picked it out. Thank you so much. there is an explicit consent we have to obtain from the data principal if you are believing that there is risk of re-identification of anonymized data. So I think definitely as a person, I don't recommend that, because this is not going to be acceptable. How can you say that as an organization, there is a possibility of risk in re-identifying the anonymized data? It means that if there is a concern, your technical issue, you're not compliant to the process which is required, right? That's what it reiterates that. But definitely what kind of process to be followed, this report may be helpful, I think. Hope I have answered your question.
Dharti, I will take only 1 minute, one line answer. I will tell you. We have to be, the companies have to be, as Taj mentioned, that there are ISO standards, there are audit standards, there is a penetration test which companies have to conduct to overcome this. It is just like a theft at the home. We take all the cares, and beyond that, we cannot help. So, but that care has to be taken, and that will not be as per Indian fashion. It will be has to be GDPR fashion, where actually real test has to be taken. So that's because we are running short of time, so I don't want to get into the detail, but I thought I will explain.
Yeah, all the technical and org measures cannot be compromised. All the preventive measures that you take would apply for any form of access to the data in the organization.
Thank you. Thank you, everyone. Thank you, lovely panelists. And thank you for the audience as well. Samriddhi, all yours.
Thank you. Thank you, Mr. Matthew. Well, it was a very, very interesting session, and we can have virtual claps for all of our panelists here. Thank you for joining us this afternoon and sharing with us your insights. So thank you once again. For those of you who are joining us now, we have now focused presentation on arbitration for IT disputes. I'm going to request our panelists from the last session to also continue to be with us for the rest of the sessions. For this presentation, we will have Mr. S. Ravi Shankar, Senior Partner at Law Senate, who will be talking to us and giving us this focused presentation on arbitration for IT disputes. And for those of you who have just now joined us, let me take you through once again the basic house rules. You can put your questions in the question and answer box during the session if you have any. And at the end of the presentation, you can also use the raise your hand icon to ask your questions. So let me very briefly introduce you to Mr. S. Ravi Shankar. He's one of the leading arbitration lawyers of India, having a strong international and domestic exposure. He is an expert arbitration lawyer handling international and domestic arbitration in the fields of construction and infrastructure, investment in joint venture, international and domestic supply contracts, service contracts, oil and gas supply contracts, etc. And he's also a qualified advocate on record in the Supreme Court of India with over 21 years of experience in the field of law. His expertise in domestic and international arbitrations and related litigation is very well known in the industry. So I'm going to request Mr. S. Ravi Shankar to now join us and unmute himself and start with his presentation. Thank you.
Thank you so much for the opportunity. Good evening, friends. I think I am between your coffee session and so I have 15 minutes to make a presentation. Before we start the regular PowerPoint presentation, I would like to share the overall view of the session. When I was discussing with the Lex Witness team, I was telling them that even after 25 years of introduction of 1996 Arbitration and Conciliation Act, even today, many of the even leading companies having high stakes are not able to conclude an effective, totally enforceable and self-explanatory arbitration agreements, which end up in various interpretations, determinations in a later stage. That too, when they are in international arbitrations, it goes to the level of determination by an arbitration tribunal or by a court of law wherever the seat is situated. So these kind of unnecessary difficulties can be resolved in the beginning itself if we give some more importance to drafting of the arbitration agreements. And when I'm going to explain this topic, I'll be explaining some local geographical specialities as well, which also have to be considered by all of you while entering into contracts, while selecting the seats, while selecting the um, applicable laws and all the procedures. Now, I have put up some points with regard to the Indian context as well. Based on my experience with some of the IT companies, whose records and whose understanding of law created certain difficulties in a later stage. I don't want to name any one of them, but these practical examples may be of some help to you while you enter into contracts with various companies. Now, all of us know well that we normally enter into three types of contracts. These days, because of the huge expansion of IT infrastructure in the government and PSU sector, the first type of contracts, what many of the IT companies are entering into, are government contracts. Government and public sector contracts normally are rigid in nature. They don't really allow you to negotiate the contract terms, particularly the dispute resolution clauses. So you have very less to say there. But in the overseas contracts, if the buyer or the user is not a huge corporation, they also will be like to negotiate certain aspects of the dispute resolution clauses. So there, how to negotiate, I will let you know a little later. And the third one is about domestic and private contracts, where in institutional arbitration is getting popular and they are really negotiable also. So now let us see in each one of these items what are the aspects we have to see before entering into the contract or keeping in mind while negotiating the contracts. Now I am talking about the government related developments in the arbitration. All of us know well, India was the only country, in my opinion, in the whole of Asia at least, which recognized legally one-sided arbitration clauses. One-sided arbitration clauses means any one of the party will have an upper hand or an absolute power to appoint an arbitrator. So this was recognized by law on the principle that you kept your eyes open and entered into the contract. In contract, there is no equity applied or unfairness can be applied. So we won't interfere. This was the stand of the courts. So we continuously, this was a major problem for the development of Indian seat in the international arena also, because people could not believe that such clauses are recognized by the courts. But finally, some kind of a relief came in 2015 when 2015 amendments came with effect from 23rd October 2015. At that point of time, government came with a bold step of ensuring the independence and impartiality of arbitrators by introducing the IBA guidelines while choosing the arbitrators, which gave three lists, all of you know well, red list, orange list, green list, which helped us a lot to control or avoid the arbitrators who are having their own interest in the arbitration in getting appointed as the arbitrator. But still, many of the developments did not really reach to the Supreme Court, so law was not getting settled. In the year 2017, the first step was taken in TRF Limited case, in which the Supreme Court held that a disqualified arbitrator cannot appoint or cannot nominate another arbitrator. That means, as per the Schedule 7, if somebody is having a relationship with one of the parties, they will not be having the right to nominate or appoint an arbitrator, which was a real good step for us to go one step ahead of in the transparency and independence of the arbitrators. Then the most beautiful judgment of Perkins Eastman came from the bench of Justice Lalit, in which he went to the extent of saying that an authority should be equal to both the parties. If any one of the party, even if he is not a person who is considered as an arbitrator, even otherwise, one party cannot appoint a sole arbitrator. So this gave us a beautiful relief. I know all of you know well, there are some confusions later created by a 3-judge bench by Justice Bhanumati, which is hope the things will get corrected in future course of time. That is only applicable to the railway contracts. I don't want to go into that right now. But generally, law as of today applicable by 2 well-reasoned judgments is has established the law that one-sided arbitration clauses are not sustainable. The next one is panel of arbitrators. That is a policy, that is a concept which is recognized by the courts. That is, PSUs or governments can have a panel of arbitrators among which only the parties have to select the arbitrator. That is a kind of restriction, but still in OL Spine case, Supreme Court held that the panel should be broad. That means it should not only have the retired officers of that department. It should have lawyers, it should have retired judges, it should have chartered accountants, and from all walks of life. So that gave us some relief. All of you should be very careful while determining your cost for the services if there are no damages clauses. Till today, no damage clauses are sustainable in law. Only exemption is that if there is a delay in the project, for execution of the project, then if you give us notice to the other party, you are expressing your intention to claim damages, then Sarvesh Chopra and all other judgments which followed Sarvesh Chopra will give you a kind of relief. So you should decide your costing based on no damage clauses. You should try to inbuilt your risks also into your cost in such clauses are available. And notification clauses, many companies even today, at least 2 of my clients who are IT companies are not taking this notification clauses seriously. That means if there is a cause of delay or if there is a delay event by which a damage has to be claimed by the party, if the contract provides for a limited period, let us say 90 days, 100 days, 120 days, then you need to follow that, because it is to check the authenticity of the claim. So if you are not following that, there is a possibility that you may not be able to claim later. All of you may think that is it not a restriction on the right to have legal remedies which can be availed within 3 years from the date of breach. There is a clear distinction made in this case of Union of India IndusInd Bank. Assertion of right is not violative of the Contract Act. But if it is limiting your right to claim, if it is limiting your right to approach the court of law or arbitration with regard to the Limitation Act, then it is void. So please be careful about notifying the party in case of delay events or events which can result in some kind of damages. Then let me quickly come into the international arbitration clauses. As I told you earlier, just keep it in mind. The first thing what you have to choose in an international arbitration clause is the seat of arbitration. Seat of arbitration comes with the procedural law. Very simple understanding is, if India is chosen as the seat, Arbitration and Conciliation Act comes just along with the seat. Singapore, if you choose the Singapore seat as the arbitration seat, then International Arbitration Act of Singapore come on its own. So you have to keep this in mind. At the same time, keep it in mind that by selecting Singapore International Arbitration Center, you are not choosing the Singapore seat. Singapore and ICC does not have any default seat, so you need to select a specific seat while choosing even the institutions like ICC or SISC. All other institutions have a default seat, but these two do not have. Then applicable laws. Three laws you have to choose. One is the procedural law, substantive law, which will help to govern the interpret the contract terms, and law applicable to the arbitration agreement. Procedural law, I have already told you, Arbitration and Conciliation Act, if it is in India. Substantive law is the law like Contract Act, Companies Act, whatever it is applicable for the purpose of interpretation of the contract. You can choose three laws from three countries also. That is what is the most celebrated principle of neutrality of seat, neutrality of law. A party from India and China need not select either Chinese law or Indian law. You can choose any other law also. Law relating to the arbitration agreement is a simple concept, that separability of the arbitration agreement. That means even if the main contract which contains the arbitration agreement is declared void, arbitration agreement doesn't go, it survives. So there is a principle by which you can choose a different country's law as applicable to the enforcement of the arbitration agreement. Then procedure, you can choose an arbitral institution or ad hoc arbitrator, number of arbitrators, appointment procedure, all those things you can decide, whichever is possible. But don't miss out the language if you are choosing the international arbitration, because many countries have default languages for their own seat. If you don't choose your language, the default language prescribed in that procedural law will become applicable, which may create a lot of problems for you. So while choosing the procedure, you choose the applicable law applicable to the arbitration proceedings. Then qualifications. It is very important that if you are going to have disputes, if you foresee disputes or maybe of complex in nature, then in your arbitration clause you can put one sentence saying that at least one of the arbitrators should be a qualified professional in the field of IT. If you put like that, if there is a 3-member tribunal, one of them will be having an IT qualification, who will be able to understand the underlying technologies much better than the other 2 members and give the required input to the members. So please use this qualification for arbitrators effectively in your this thing. And the other quick things is many of the IT companies, you do communication with your clients and service providers also in WhatsApp and such informal way. But please record those things also. Those are also permitted as evidences in case of an arbitration, but try to make it formal. Formal communications, you should have a program supervision team or something. They should keep on updating both the parties about the status of the execution every month or every week, every fortnight. That will put you in a strong position if there is a dispute arises. And we have seen many of the regular IT reports are not complete and they don't really demonstrate the breach in the contract. So please revise your IT progress reports to suit with the requirements of legal requirements also. And there are wonderful facilities like document only arbitrations, which are very much sufficient for IT disputes. So if you put such clauses into the arbitration clause, it will really help you to resolve the issues much faster. And now all online institutional arbitrations are available. 17 arbitral institutions in India are recognized by Ministry of Law and Justice. Please choose one of them and use them as your arbitral institution so that you need not travel to the seat. Opposite party also need not travel into the seat. They can very well administer and produce or deliver fully enforceable arbitration awards under the New York Convention. There is no bar for that. So you can cut down costs by using the online arbitral institutions. Thank you so much for the opportunity. If you have any questions, you can post it.
Ravi sir, there are 4 questions in the Q&A box. If you can please take them one by one.
Yes, I'll do that. I'm not able to see the questions in the chat. Oh, it's in Q&A. Okay.
Yeah, the Q&A box, sir.
Can you explain what is notification? What is a notification? That means, as I told you, when the execution is going on, if the opposite party is in some breach, for example, you are giving your IT plan for the approval of the client. The client has to approve within 30 days, but they are taking it 90 days. So your execution plan gets delayed. In such a situation, you have to raise it as a dispute within that particular period. At least you should express by way of an email that because of your delay, there is a delay in the execution also. So we reserve our right to take actions later if required. Otherwise, tomorrow they can come and impose liquidated damages on you. So this is what is the notification is. And the next one is it mandatory in contracts to have arbitration clause? It is not mandatory, but it is recommended, because you know very well, if you don't have an arbitration clause, there are many issues coming in. One is you have to go, if it is an Indian dispute, you have to go to the Indian court. And our courts are taking huge number of years for getting a conclusion in a commercial matter, which no commercial person can survive. If it is an international arbitration, then going to the respondent's place, filing a suit against them is a totally expensive and unpredictable uh, exercise. That is why if you choose arbitration clause, you can choose the place where you want to have the arbitration. You can determine the cost. You can choose the arbitral institution who is going to administer. So it is recommended. Is arbitration award time bound in every arbitration process? Yes, in a way, I don't say it is time bound, but you see, in Indian law, there is a beautiful provision saying that if you want to challenge an award passed in India, you have to deposit at least 75% of the amount to get a stay. Otherwise, you can proceed with the execution. So it will really help than the other procedure. Next one is what is the new revision in the LCA rules? Yes, LCA rules, one of the new revisions is with regard to the confidentiality of the proceedings, which is welcomed by everybody. They have also changed their fee schedule to some extent. That is also an important change in that. Can two Indian parties with an arbitration seated in India exclude the applicability of Arbitration Act, assuming that the parties have... See, if you are having the seat in India, you cannot have a foreign procedural law, because by common sense also it is not possible. Because if you, for example, if you take Singapore International Arbitration Act, then you have to go to Singapore for any appeal over the decision of the SIAC's registry, or you have to go to challenge the award to Singapore. It doesn't really work. That is why it is very clearly established in law. If you are choosing a country seat, that Arbitration Act is the procedural law. But arbitral institutions can administer arbitrations anywhere in the world. SIAC, ICC are having many arbitrations happening in India between Indian parties, but on the basis of the Indian procedural law, not on the foreign procedural law. Online arbitration process is a process by which parties don't move to any place. You can You can complete your pleadings online. You can advance your arguments online. You will also get the award by online. That means you will get a hard copy award and as a soft copy award also. Now virtual hearings are becoming so popular, and this online arbitration will really cut down the costs like anything. And please go through the Ministry of Law and Justice website, which gives a lot of information about online arbitration process. Do we need to incorporate and agree in the written agreement for online arbitration? Yes, because the other party can object later. But you should understand the difference between an online arbitration and the virtual hearings. Virtual hearings in a regular arbitration is a procedural change which can be decided by the parties jointly or the arbitrator can decide. But online arbitration is a totally different process. So parties have to accept it in the arbitration before the starting of the arbitration. Can two Indian parties opt for foreign seated arbitration through foreign seated institution arbitration? That's what, there is a debate going on in this. But as of now, as per Balco, Indian parties cannot circumvent Indian law. So foreign institutions can administer arbitration in India in Indian law, as per Indian law, between two Indian parties. Online arbitration, once again, I'll explain you. For example, you will be filing a claim application. Once you opt for an online arbitration institution will give you a username and password. You will upload your arbitration request in the page given, and then they will circulate the arbitration request to the opposite party, share the proposed arbitrator's name to both of the parties, and allow both of the parties to file their pleadings online in the portal given by them. And the arbitrator also will conduct the hearings online till the arguments are over. So that is the online arbitration. And if you require any personal means help, you can always call me. I will just explain to you more.
Thank you so much, Ravi sir. We have a live question request. I'll just, Mr. Varun Kalsi, can you please ask your question live? Mr. Varun Kalsi, can you please unmute yourself and ask your question live? No, there is some technical problem. So there are a few more questions. Can you please take up, although we don't have time, but I would still want you to pick up.
Can you propose the name of you India Institute for Arbitration? Yes, if you are in Delhi, you can do the Delhi International Arbitration Center. Mumbai, there is Mumbai Center of International Arbitration. And there is an institution called IDAC India who are also offering online arbitration services, and they have office in Mumbai and Baroda. There is an institution, Palkiwala International Arbitration Center in Chennai as well as in Delhi. There are many arbitral institutions. And if your stakes are high, for parties want more professional approach, then maybe you can choose international institutions as well. Can we ask for online arbitration even if it has not been contractually agreed? Yes, if both the parties can do anything, both the parties prior to starting of the arbitration can jointly request for an online arbitration. Yes, in my opinion, the award against the future group will be enforced. That is what, but to see two stalwarts are appearing, Mary Salve and Gopal Subramaniam. Let us wait for the result. What is the role of International Arbitration Tribunal? International Arbitration Tribunal is either appointed by the parties or appointed by the International Arbitration Institution for resolving the disputes. It doesn't have any difference between a domestic arbitrator and an international arbitrator. Even if it is a single arbitrator, they are called as tribunal.
That's all, Ravi sir. We still have a few questions coming in to us offline. We will pass them over to your good office,
Yeah,
sir.
please.
You can address them through email. I'm really sorry we're running short of time, sir. Otherwise, we would have taken up more
No,
questions.
it's okay. It's okay. You can ask
Thank
them.
you so much for your time, sir.
Thank you. Thank you so much. It was a great opportunity.
Thank you, Akshay, and thank you, Mr. S. Ravi Shankar, for joining us this afternoon and sharing with us your expertise. As Akshay mentioned, the other questions that were not taken during today's webinar because of time limitations will be addressed to offline. So for those of you joining us now in our today's webinar, our next session is on employment law fevers temp check. Before we begin this session, once again, a very quick mention of the house rules. You can ask your questions during and after the session. During the session, you can ask your questions by putting them, posting them in the question and answer box that you can see on your screen. And post the session, you can also ask your questions live by choosing the raise your hand option and ask your questions live to our panelists. We're now going to begin with our next panel discussion on employment law fevers, temp check, and this session will be moderated by Ms. Lakshika Joshi, Legal Leadership and Global IP Head at Altran. And Lakshika, as the Global IP Head, is a part of the legal leadership at Altran, bringing together over 25 years of industry expertise and unmatched global scope to help our clients scale their efforts within intention. As head of IP, Lakshika is leading the company to manage and monetize its IP for unleashing a greater, newer potential. With unparalleled domain expertise in a truly global organization, Altran is the world leader in engineering and R&D services. Altran acquired Aricent end of 2017 with more than 10,500 employees before the transaction closed in March 2018, significantly expanding Altran's leadership. We also have with us Alpa Sood, Senior Attorney, India at Marvell Semiconductor. And Alpa is a legal counsel working for software-enabled product manufacturing sector. She is skilled in corporate law, M&A, legal advice, commercial litigation, intellectual property, and contract drafting and negotiations. A thorough professional with a BSL LLB focused in corporate law from the ILS Law College. Then we have with us this evening Mr. Danny Kumlo, Director Legal at Conduent India, and with over 15 years of experience as the in-house counsel with exposure in employment law, litigation, real estate, compliance, and legal contracting, with added exposure to providing legal support to diverse functions like HR, finance, facility, purchase, physical security team, corporate marketing, sustainability, sales and project team, etc. Proven record of dealing with varied employment law issues, dispute resolution, litigation management, and variety of commercial contracts, and dedicated and persuasive with a good track record in dispute resolution and litigation defense. Then for this particular session, we also have with us this evening Ms. Namrata Sudan, partner at Dheer & Dheer Associates. Welcome, Namrata. And Namrata, over the years, has specialized in both IPR and corporate commercial practice and has handled a wide mix of matters, including cross-border transactions, MOUs, labor and employment agreements, real estate agreements, and transactions relating to media and technology, telecom and IT, and has also advised clients on regulatory matters as well as on enforcement of protection of intellectual property. And last but not the least, joining us for this panel discussion is Mr. Naveen Chandra, Regional Legal Counsel at Kenna Metal, and in-house legal counsel with over 13 years of experience in both litigation and non-litigation issues in varied industries, IT and communication sector, infrastructure sector, aviation industry, the FMCG, apparel and fashion industry, result-oriented professional with excellent communication, interpersonal skills, advising on strategizing, action plan in high-stake litigation cases and business strategic decisions as M&A, JVs, acquisitions abroad, etc. So with that, I'm going to welcome all of our panelists. Hope everyone's healthy and keeping safe during COVID. We thank you for taking out time from your schedule and joining us virtually for this conference. And with that, I'm going to hand it over to you, Lakshika, to take it forward from here. Thank you.
Thank you so much, Samriddhi. Thank you all. Thanks to the panelists and to the Lex Witness team for putting this together and having us all here talk about these key issues. I think these are some of the issues that all of us have encountered at some point or the other, whether as a practitioner or as an in-house counsel. And they become even more important now because of the challenging times we've seen recently. So, I know it is an IT law summit, and perhaps for a minute, one would sort of want to think and look back on, is the topic really talking about labor laws? Yes, it is. So for some of you who are, still sort of sipping on your evening tea coffee, we are indeed talking about labor laws, and these are extremely pertinent also for the IT and software sector that the summit is all about. So just sort of to give a little bit of context, and we've got excellent panelists here, so I would let them talk more about how it becomes even more pertinent in these challenging times. But just to give some personal thoughts here, I know all of us are aware that the 2020 report on doing business is out, and if you notice, India actually jumped 14 places again. So between 2014 and 2019, we've sort of jumped 14 places from 79th rank, almost equivalent to 80. We are on the 63rd rank. And some of this has been possible because of the kind of reforms we've seen in various sectors across industries. I think one most wanted and much awaited reform that was awaited was now in the labor codes. Yeah. And this is what we will be talking of today. So basically, the government wanted to have these new codes and sort of have them consolidate most of the labor related regulations and laws into one and make the country an investor friendly, enterprise friendly sort of environment, which gives a lot of ease of doing business to investors, and therefore also in these tough times perhaps attract investments, attract also boost economy, if I can say so. So just to give an overview before I hand over to my esteemed speakers here, what really has happened, and this overview is for some of the people in the audience who are like me, who perhaps you know about labor laws, they're applicable, but then at some point you don't take enough interest because with no matter what amendments or whatever happens, it doesn't really apply to you in person. But just to give an overview, what the government has done is actually tried to consolidate the hundreds of acts that were earlier present into 4 large categories. The first category is the Code on Wages of 2019. This seeks to replace your minimum wages, payment of wages act, bonus act, remuneration act, and so on. So anything and everything to do with wages comes here. Then there is Occupational Safety, Health and Working Conditions Code of 2019. This seeks to replace actually about 13 labor laws which relate to safety, health, and other working conditions. It also includes laws like Factories Act, Mines Act, Dock Workers, Contract Labor Act, and so on and so forth. Also includes the State Migrant Workers Act, by the way, which is extremely important, and we've seen a lot of issues around that during these times. The third category, or the bucket it has created, is of Industrial Relations Code, where all your Industrial Dispute Act, the TU Act, and all of that, the standing orders, the Industrial Employment Standing Orders Act, etc., will be sort of consumed. And the fourth category is of Code on Social Security. This replaces the 9 existent labor laws on social security in India, such as the EPF, the Maternity Benefits Act, Unorganized Sectors Social Security Act, and so on. So these are the four heads, and I think as an in-house counsel, as a GC, it's actually adding a lot to the ease of doing business and also being able to be compliant more with each of these, definitely. But having said that, because we all have been reading news and we all have been party to a lot of criticism also that has come about with some of these reforms or some of these proposed acts. And I will actually, with that, lead on this discussion to our first speaker on the panel, which is Danny. And I would like Danny to explain to us here some of the key benefits or advantages of these changes or consolidation that he sees it will bring about, with the changes in these labor laws. Danny?
Yeah, thanks, Laksika. Laksika has given a wonderful intro, so I'm not really going to go into the introduction. Now, these labor reforms have been on the card since the 90s, but for some reason, political or otherwise, never happened. So first thing, I think credit is due to this current dispensation for actually taking the bull by the horn and bringing this much needed labor reform. As Laksika had put it, now the courts, all 44 central legislations have been finally amalgamated into just 4 courts, which I will not go into the details in the interest of time. Now, I will be referring to these courts as the reforms of the courts simply in the course of our conversation. Now, the question is the labor reform progressive or regressive, right? The arguments we generally hear are generally from the different end of the spectrum, those in favor of the workers' interests versus the industry interests. Now, in my view, this positioning is a fallacy because I subscribe to the rationalist view that there should be an improved condition of workers and simultaneously increase competitiveness or growth of the industry. All of us know that a sound working condition is not possible if you are employed in a company that has no growth or prosperity. So both sides have to be taken care. So then the question is, has the new labor code managed this fine balance between protecting the interests of employee and employers? Now, the jury is out, and I'm sure all of you have your views on this. So I'm going to be discussing the reforms. Because of the paucity of time, I will not be able to reflect into all the details of the changes, but just the major reforms with this background, whether it is progressive, regressive, does it protect employee interests, employer interests, right? So there is a section of the group, and mostly trade union and activists, who are very disappointed with the reforms. According to them, the reforms will eventually create a permanent cadre of insecure and temporary employees. So we need to understand, why do they say this, and what are the biggest disappointment? Perhaps the biggest creep is the one that we keep seeing on television discussion happening as well. That is the increase in the threshold from 100 to 300 for taking prior permission of the government for retrenchment, layoff, closure. According to them, this is giving employers the right to hire and fire, and workers' right to a safe job or livelihood has been dispensed with. Now, the counter argument is that the change will enable smaller firms to actually grow and provide more employment opportunities. Now, there are examples of Rajasthan being given, because even before the court came, Rajasthan had implemented this legislation through a state ordinance. And if the data of the Rajasthan government are to be true, there were a lot of employment generation, because smaller firms could now increase their employee size from 100 to 200, 250, etc. Right? And there are also counter arguments that there are enough protection being given in the IR code, and the retrenchment provisions which were in the ID Act is also still being retained. Plus, we have additional provisions or burden on the employer to pay 15 days wage for reskilling, which have been introduced by the court, right? So the second creep is the applicability threshold of standing orders. Now, similarly increased from 100 to 300. So the argument is that this will exclude a considerable section of small and mid-sized companies from the ambit of the standing order. So what is a standing order? All of us know a standing order is a sort of a rule or that a company needs to follow before it terminates its employees. Now, the argument is that because most of the companies are being excluded, this will give employers an arbitrary right to fire without following due process. And the third, which is the change in some of the trade union rules, which I know certainly has ruffled the feathers of the unions. The right of workers to go on lightning strike or strike immediately has been strictly curtailed. Now there is an advance notice of 60 days before a strike. And additionally, strikes also now include mass leave on any given day by 50 or more workers, which means that unions cannot resort to mass leave as an alternate to strike, right? So both that sort of uh, has been plucked by the government, because there were a lot of industry complaint that the union is sort of dragging back to industry and always bargaining with the employer on unequal footings. Now, again, the other point is that Parliament has given too much freedom to the government to exempt industries from the coverage of the court, to define the limits within which they will operate, etc., etc. So the fear is that this will be used by the employer-friendly governments, because we saw the trend even before this court came of the changes happening in UP, MP, Karnataka, Rajasthan, etc. So the fear of the unions is that the governments will use this to subdue the right of workers. They will come up with new rules to subdue the right of workers. But we need to understand that labor law is on the concurrent list, which means it is the subject matter of both the center and the states. And even this code, which has been passed by the parliament and has the president accent, still needs the state governments to frame the rules for its implementation. And obviously, the success of these rules will also depend on how the states actually implement it, right? And the last point is on the applicability threshold of social security provisions like EPF, ESI, maternity, gratuity, which have remained unchanged. Now, the argument is that this still excludes many workers in the unorganized sectors. Now, the other side of the argument is that these reforms will spur much needed investment and create more jobs in the country. And there are several worker friendly provisions which have been included. So, for example, now the reforms have included more category of workers. Many unorganized workers, such as agriculture workers, painters, gig workers, freelancers, home-based workers, interstate migrants, platform workers, etc., who were not in the ambit of the previous labor law, will now be eligible for all the social security provisions like minimum wages, social security, health and safety benefits, and other benefits like annual health checkup for workers, which have been made mandatory, issuance of appointment letter for all category of workers, right? And provision of leave has been increased. That is 1 day leave for every 20 days work, which was calculated, which is now to be calculated on 180 days against 240, which is the current rule. And EPF coverage would now be applicable on all establishment having 20 workers. At present, it is applicable only on establishment which are included in the schedule. And the coverage of ESI has been extended to more than 740 districts in the country. And option of becoming members of ESI now is extended to establishment with less than 10 workers as well. Now, we spoke about the 15 days salary as reskilling in the event of retrenchment. A new category of workers, and I think this is one of the big items, a fixed term employee is introduced. Now, what this means is that companies can employ employees on a fixed term basis, maybe 1 year, 1.5 years, etc. But the flip side is that these fixed term employees will enjoy all the regular benefits which an employee enjoy, including the gratuity. You must be wondering, how will gratuity apply? Because there is an eligibility of 4.5 years. Now, for this category, that rule does not apply. They will be paid on a pro rata basis when they leave, right? And there are other provisions like home journey allowance for migrant workers, CRES facility, which was already there, introduced by state notification by several states, but already included in the codes now. And certain provisions in the event of transfer of undertaking, like principles like not less favorable terms if you are transferred to another employer, etc. And in the event you're not absorbed, retrenchment provisions has to apply. Such things have been included. Now, those are some of the benefits, but we also need to discuss few of the changes that will, in my view, reduce confusion, reduce operation overheads, reduce bureaucracy, introduce more transparency and accountability. Now, The first point is we always had this problem of multiplicity, overlap, and unclear definition. There are, for example, take the definitions of establishment, industry, wages, workers. We had that several definitions under several legislation, which were creating unnecessary confusion and prolonged litigation. Now, what the court does is one definition, which means the definition is clear and there is no more scope of interpretation or confusion. Now, on the regulatory front and filings, the number of registers, returns, forms, etc., have been considerably reduced. And in fact, more documents are also allowed to be submitted electronically. Example would be a standing order. Now, if you had to create a standing order, you can just send it electronically. You don't have to go and apply and get the seal thapa, etc. Trade union registration, notice of closure, etc. And hopefully the court will also introduce more transparency. That is the intent of the court. Many changes have been introduced in the inspection rules, including the web-based randomized computerized inspection scheme, jurisdiction-free inspection, calling of information electronically for inspection, compounding of offenses, etc. And there are some changes in terms of the dispute resolution as well. Now, the courts have removed this multiple adjudicating bodies. Like right now, you could just get an email or a notification from the labor officer asking you to present because an employee has just dropped an email or filed a complaint. You go there, and then after that, if the employee is not happy or you lose the matter, you have to approach the labor court, and then it goes to a trial court, high court, Supreme Court, etc. Now, what the courts have done, the courts have provided a conciliation officer and industrial tribunal or national industrial tribunal, which will deal with labor matters, right? And penalties have been enhanced. Please be wary. The penalties have gone from thousands to lakhs now, and even the imprisonment have been enhanced. So the government is also expecting accountability from the companies. And before I end this, there are a few sort of Diwali bonus for India incorporation, which have been included in the code, right? There is a limitation period for filing of disputes, or which is 2 years. Now, in fact, this is 1 year lesser than our limitation act, right? And most importantly, limitation period of 5 years for look back in terms of disputes or payments to be made regarding EPF and employee state insurance. And I think this has been one of the confusion or a sword that has been hanging on most of the HR or labor compliance officers, right? Where an inspector can come and ask you for records which are 10 years, 15 years. That clarity was always missing. And now we have the clarity. And women working at night shift, we had state notifications. Now it has been clarified, included in the code. 7 p.m. to 6 a.m. they can work. The similar sort of conditions have been included. Now, in conclusion, the courts may not be that perfect, but it is a good start and a forward looking to a progressive labor reforms. That is
Thanks,
all that I
Danny.
have
I
to
think
say.
that's
Yeah.
pretty exhaustive. You sort of covered a lot of points there, and rightly so, because these four codes are actually encapsulating hundreds of acts that were present earlier. So they cover almost anything and everything under the sun that pertains to either a workman or labor or industrial relations and so on. So there's a lot. I think it's sort of an unending list, and why I say unending list is because this is what we see apparently right now and what we can comprehend, but some of it will also become clearer as we go along. And I think the much of the criticism is also because of the fact that it is too much into shorter time, and it's difficult for people to comprehend the long-term impact of such a big change, if I can say so. It's a really, really huge step that we've taken towards sort of building a new nation. Again, with that, Naveen, I would like to jump to you and get your thoughts on some of the key points you think here that will change the way we do business. You yourself would have seen the environment and in the company where you work or the organization where you work, how it impacts, for example, and this is just for example, you can you feel free to quote others or pick up something else you have in mind, but the whole concept of work premises has been sort of increased to include not just your official physical premises, but wherever you're functional from. So how does that impact? And especially in these times where most of the workers will either be working from home or will be operational from some other place, but not from a designated official leased premises or owned premises by the company. So how does that impact? And, others, let's say 2 or 3 key points you think which have changed the way we will do business.
Actually, thank you so much, Lakshika. Danny has covered most of the aspects, so I would try not talking more about law. But then, in my view, I think this is a great start. It's a historical step, I would say. We see decriminalization of offences under the Companies Act 2013. Mainly to attract more and more investments. The government is also looking at how to make sure that the enforceability in several areas are relooked, and in that, and they're also looking at public procurement, wherein they are laying the thrust on in Make in India, especially they are mandating that there has to be 50% local content in each of the public procurement that's going to be made by the PSUs, which is all of this, and on the other hand, you also have this labor codes coming in. So all this is towards reforms, and this is a major step, I would again say, because each of the political parties were in a way affiliated to one or the other trade unions, and no party that way is an exception. But this is definitely a historical step and a bold step by the government. Coming to the work from home, the COVID in these volatile, uncertain, complex and ambiguous environment that and unprecedented circumstances that we exist in, our home spaces have turned out to be office spaces. These have posed a lot of challenges to the companies in terms of cybersecurity, in terms of ensuring privacy of of the individuals, of the employees, confidential informations of the customer. We no longer have that luxury of having all the robust security systems that we otherwise enjoy in our offices. Just to lay a background before I briefly touch on the privacy aspects of it, because Danny has covered most of the legislation points with respect to the codes. While I leave it to other panelists to comment on POSH and other aspects, I would briefly touch on privacy. The courts in India have largely, laid out that if a patient is running a risk of transmitting a disease to another, that is a good reason for the right of privacy to be limited. Now the question is, if you look at the Puttaswamy judgment, it lays down, the famous 3 principles. One is the legality, which postulates the existence of law. In order, if you have to invasion the personal liberty of a person, then there has to be a legality which postulates the existence of law. And secondly, there has to be a need, the objective of the state. And thirdly, importantly, proportionality which exists, which creates a nexus between the objectives of the state and the means adopted to achieve those objectives. So why I'm reiterating these 3 cardinal principles, especially laying stress on the proportionality, is this also defines to a large extent on how we frame our policies within the corporate while dealing with the privacy of our employees. Now, before I step into some of the aspects what the corporates may intend to look at in these, to protect the privacy in these COVID circumstances, it would be interesting to understand the legality, the existence of the law on which it is based on. Largely, if you look at the May 2020 privacy policy promulgated by the central government, it is hinging on the National Disaster Management Act 2005 for the simple reason that the PDP is still a bill. It is yet to see the light of the day. There are, as everybody knows, there are reliefs prescribed under IT Act 2000. There are also remedies under IPC and Specific Relief Act, etc. But with a view to make sure to mitigate risks for corporates, especially and obviate any kind of litigation possible while you are dealing with sensitive personal data or information. So SPDI, sensitive personal data on information, refers to physical, psychological, mental health conditions, medical records of your employees, of your stakeholders who are visiting your plant, visiting your premises, and all of this. It is very essential that we take care of this particular data and relook at our work from home policies, because work from home policies in corporates would basically talk about scenarios where you are entitled to work 3 days in a week or 4 days in a week, etc. In contrast to that position, we have moved out to a position where 24/7 we remain available, to for working through homes. And as I said, our homes have got transformed into workplaces. So in that sense, it becomes necessary to relook at your work from home policy, number one. Number two, it is also essential that we look at the privacy policy, because some of the challenges posed by the COVID-19 in terms of privacy largely relates to redefining and relooking the purpose, with which we wanted to collect, personal information. It might have changed. There have been numerous examples. Paucity of time, I'll not be able to lay out everything. For instance, some of the corporates were trying to, as a benefit, to all the employees, they were trying to pass on the personal information of the employees to buy COVID insurance policies, and one of the employees, raised out an objection in a general meeting to say that, why did you share my information? So where did you take my consent? And who is this insurer? Do they have appropriate rights? Have you signed a non-disclosure agreement with them? So some kind of practical challenges, where they had to relook at, some things. And the sunset clause, the right to be forgotten, data minimization, data retention policies, fair processing of details, making sure that our the people who are, especially the HR folks who are working on these employee information, are using the company owned systems. They don't log on from a resort elsewhere, using their private laptops. They are connected on a VPN network appropriately, just to make sure that they are
So
covered.
Naveen, I'm sorry to interject, but while you're at it, and this is just a rain check for the audience. Audience, if any one of you has encountered within your organization such practices where you were asked to submit some personal sensitive data, or the organization was collecting that personal sensitive data, whether it was for some kind of insurance policy, health related reasons, or as we all know, during COVID situations, organizations have been trying to give all of us a secured, healthy environment, and therefore, that may be a consideration. So while Naveen is talking about the subject, I'm just curious to understand, one, if all of you are still awake, and two, if you've encountered such a can you please share that on the chat box, and then we will come to you, whoever has had such an issue, and perhaps it will be interesting to hear from you. So thanks. Sorry, Naveen, I just couldn't resist, but I had to do this rain check.
No problem. Sure.
So what you're saying, Naveen, is that the whole paraphernalia actually will need to be seen in light of various laws. It's not just the labor codes, but also how the data protection laws are sort of governing certain provisions. And then not just the laws, but how we execute them through our policies, whether these are HR policies or these are organizational policies, and implementation becomes extremely critical, right? That's what I heard you say. So, I mean, thank you. I mean, those are really great thoughts. And I really liked your point on the whole Make in India and vocal for local concept, because that connects very well with what actually the government finally intends to sort of, and how they finally intend to join all of these dots. All of these reforms are not without a reason. They're all geared towards a certain objective, and that objective is something that's going to then perhaps work towards that long-term goal of nation building.
Absolutely. Yeah.
So with that, Namrata, I'll move on to you. And because we are talking about the practical aspects, and I know, this has been one of your expertise. So, I mean, I'm really curious as an in-house counsel, and many of us are on this panel and in the audience, to know from an execution implementation perspective, how does it all change for us? Like, do I do something different now with my contracts? Do I write things differently? How do I negotiate with a new person I'm planning to have into my team or elsewhere? How does it all change on a day-to-day operational basis for the industry?
Thank you, Lakshika, for the question. We are all aware that coronavirus disease has been quite disruptive and has virtually affected all facets of life, including workplace relationship and productivity. When the government declared closure, lockdown, a lot of businesses and offices got shut down, and staff was working remotely. Now, slowly the life is getting back to normal, but it will take some time. There are many organizations which have declared opening up their office from January 2021. And since there was such a great change between employer and employee relationship, obviously there was a need to revisit your employment contract. I also saw a lot of queries regarding revisiting the current policies, including work from home policy, which IT industry, some of the IT giants did have the work from home policy, but other industries were not following it because they never envisaged such a situation, because we never thought that coronavirus will impact us this way. Having said that, we all know employment contracts are legally binding. They govern relationship between employer and employee, and they contain material terms regarding working hours, salary, compensation, termination, etc. Now, what I have seen in the past few months, we've had a lot of queries from employers, because obviously there were a lot of issues, they were facing regarding disruption of workflow, reduction of revenue. In fact, there were certain organizations, there were no revenues at all. I mean, there was no generation of revenue. Then employees were underutilized. We saw terminations, we saw pay cuts, suspension of salaries. And there are certain organizations which are still facing restructuring. So obviously there are a lot of things that were happening, and we received a lot of queries from our clients regarding re-looking at the employment contracts and if they can change certain terms and conditions. And my advice has always been to the employers that unilaterally employment contracts cannot be changed. It's basically the consent of both parties. We enter into any contract, there's consent of both employer and employee. So if you want to change any employment condition per se, then you have to seek consent of the employees. And surprisingly, there were certain organizations where employees were happy to negotiate rather than going for complete redundancy. At this time, looking for a new job or position where organizations are kind of reducing workforce, for them it was a very good situation to renegotiate certain employment terms. So some organizations re-looked at certain material terms which included compensation. For example, negotiation of salary, reducing certain number of hours, resulting in reduction of salary. However, the contract rate per se, I worked on quite a few contracts. Contract rate remained the same. That remained the same. Only they were reducing the number of hours and the salary component, of course. Then there is some of the organization re-looked at the termination clause, because earlier termination clause only covered termination for a cause, but now they wanted to have termination at will. And for high senior managerial employees, they also wanted to be sure of the data sensitivity. So there were these clauses. The clauses that were really looked into or looked at this time were compensation, working number of hours, reduction number of hours, having happy or a termination clause where employer can terminate the employee at will if there is any reduction of work per se, and employer cannot involve or cannot keep the employee busy. And also a lot of focus was on data privacy. Naveen rightly touched upon it. A lot of focus was on data privacy and data protection clauses, especially some of the contracts there were instances where some of the clauses like this were missing. So they were inserted, or the present clause were re-looked at just to make sure that company's interest is protected. Not only that, I also saw there was a clear shift from having a normal regular standard policy to customizing your policies now, such as for work from home and return to work policy. Now there is a return to work policy in place. Now I recently kind of advised a client on it, where they wanted to have a proper return of policy, having standard operating procedure for what you're going to do, how you're going to come to office, sanitization and everything. And work from home policy again has been put in place because employers were, slightly concerned, or I would say not slightly, they were majorly concerned because they've already signed contracts and agreements with their customers, and they've already kind of, sworn into keeping the data confidential, and they don't want a situation where employees kind of misuse the data, or their computer is being used by family members, or there is a complete breach of privacy. So that was something that they really were very, very concerned about. And also about when we have our employee working from home in this current situation, we would not want our employee to kind of go to any, like Danny said, resort, or Naveen said, I think, a resort, or any kind of a place which has not been agreed to, or with the employer. So I am allowing you or permitting you. And in fact, I would say that any change in your present employment contract or any change in the policy must be acknowledged by the employee. If you want your employee to, or your permission is only to have the employee work from home, make sure it is narrowed or restricted to that. If tomorrow I choose to work from McDonald's and I contract COVID, then what happens to that kind of issue? So this is the reason why work from home policy has been put in place. I'm also very happy to say that there are certain, even some posh clauses have been put in work from home, because earlier nobody ever envisaged that we'll come to a situation where we will be virtually handling posh complaints. So they have also kind of defined, like, if you're working from home, that becomes your workplace. So a lot of things are changing in a good direction, because people were not really, we all were never not prepared at all. Now employees are more aware. Employees are also kind of quite aware. From employee perspective, I can only say one thing, that obviously your employer cannot change any service condition without your consent. So make sure if there is any change in service condition which you're uncomfortable about, speak, and you can renegotiate. As far as employers are concerned, employees have to be mindful of one thing. If you're changing any kind of service condition, or you're entering into a new contract, or any addendum to employment contract, then you must have it signed. It has to be recorded in writing. We can't have something that you and I discuss and then leave it at that, so that tomorrow there is you can kind of avoid employment disputes in that case, because if you already have a recorded document, executed document, that will help you to kind of save yourself from any kind of risk or liability after that.
Those are some very wonderful points. In fact, Namrata, somebody had posed a question earlier, and this is the first question that came on the platform, which said, how does new labor code handle unfair labor practices? So I think some of the things that you mentioned about recording consent from the employee and other things, these do take care of that to a large extent. But again, if you would like to answer that in detail, please feel free. And I'll circle back, by the way, with on the POSH related points that you made. But again, you can answer this point right now, because it's a question from the audience.
Yeah, Lakshika, I see. It's very important. Now we are going to, we're in transition phase. I would say that we are going to move to labor codes very soon. We will see a lot of structuring happening in the structuring as well as evaluation, I would say, happening in the existing employment contracts, and as well as going forward, if you're hiring someone, then there will be a lot of structuring will go into it, especially when you're looking at the compensation, because now wages has a different definition altogether. Anything which can be expressed more in a monetary terms is wages. So basically, you'll have to see all of. We will obviously will witness a lot of changes there as well. Having said that, unfair labor practice. See, I feel that as long as both employer and employee are negotiating in this time during this time in good faith, whether it is the change is temporary or whether the change is permanent. If the change is temporary, and then also, if everything is, if you're negotiating the critical material terms in good faith, there should not be any problem. And also, I feel that judicious changes to employment contract could give employers valuable flexibility to operate in the emerging post-COVID world of work. So the changes should be judicious. It can't be arbitrary. It can't be one-sided. And in any case, I want to place on record that I have handled. I've also kind of recently handled a query where from the employee of an organization where he felt that he was being arm twisted, because he felt that since he cannot go and find job as compared to pre-COVID era or pre-COVID times, where he had other options, he felt a little hard pressed. And where you feel that as an employer, if you feel as an employee, you feel that you're being hard pressed, it's the right time to talk to your management, and that is, and as employer, it's just your duty, or probably it's a moral duty or obligation to make sure that any term and condition, if you're making any change in the service condition, then it has to be agreed upon very clearly, and the changes cannot be arbitrary, or it should not kind of give anyone impression that you're taking undue advantage of someone. So if you are taking judicious decision and making judicious changes, I don't think there should be any problem.
So Namrata, there's another specific question from Mr. Sanjay Kumar to you. Can workmen be terminated at will?
Yes, can work. Yes, of course, workmen can be terminated at will. If obviously you'll have to follow the you'll have to follow the law provided under the Industrial Dispute Act, and you have to follow the provisions that are laid down under Industrial Dispute Act. If it strictly falls on the definition of workmen, yes.
Thank you. So with that, I would like to move on to Alpa. Alpa, I know we've all talked a lot about changes and some of the things that we are sort of going through. These are tough times, these are challenging times, and I think what we would like to understand from you again is more on, and I also see a lot of questions on the work from home remodeling policies being remodeled, and the whole thing getting consumed into policies of organizations, and even organizations who never even considered those options are now seriously, or they had to, or let me say they were forced to sort of opt these. So how do you think that has changed? What are some of the structures, benefits, and the employment or the employee matrix you've seen around that, and any necessary steps that organizations have taken to sort of execute these? If you could highlight that a little bit, because perhaps that might also cover the question that we have currently from the audience. If it doesn't, then we'll pose that and we'll bring the question live and we'll pose it to you and or to others in the panel.
I think that's what you say is absolutely right now, Lakshika. We did see a work from home shift. We did see the remodeling. We did see the new terms being coined. One being, the employer's definition of being a friendly organization has now moved to being a good infrastructure with a safe organization. safety has become paramount more than, and if all employers understand that, be it an industry where the factories are located, be it a workforce where IT employees come to work, to everything is now revolving around safety. And safety, when I talk about employee safety. I also talk about the cyberspace in which we operate while we are working from home. So both have become very important. Now, while the organizations are looking into return to work, that was another point that was raised by Namrata, there are parameters that they are considering. And that is how this is the new shift that we see, the flexibility that we see now. There are people who are needed on ground. That's the reality. We know that. Even from an IT industry perspective, we need people on the ground. And how are now companies looking at it? The organizations are looking at how I would analyze into 3 buckets. And one being need-based availability. That has become paramount. The second being documented approach, where the organizations, the smaller organizations who would have not thought about a visitor management system, they're now tapping into it. They know that everything has to be documented. That's the only way ahead. There cannot be no paper rolls around, which you do not know who came in, who was here, for how long. That's now become a shift to how safe your workplace is. Third being tech-enabled accessibility. Now, that is, again, a very interesting way how IT industry especially is tapping into a world where they're trying to do Bluetooth bands to ensure people are maintaining social distancing, facial recognition, where they can tap the whole workplace into systems where they can see how people are moving within that particular office space. So those are very innovative ways, and the structures that I have seen from an organization standpoint that have come, and this is just because of the pandemic that we have in our unprecedented times that we see. But this has actually brought in a very good perspective and a new perspective. From employee benefits, when I talk about, I think health insurance has seen a major tap into where this has become a criteria. Earlier, we would see our US counterparts talking heavily on health insurance, negotiating with their employees on health insurance. But now, from India's standpoint, we see that happening as well. Employees who are looking into the talent management, we are looking for wider insurance coverages. We're looking for dependents, non-dependents, who all can be covered. And I think that is something that definitely in the next labor reform that we will have a wider coverage for our blue-collared employees also. That is something that I would love to see, honestly, where blue-collared are given more than what ESI offers, and that is another negotiation point for hiring blue-collared employees as well. So I think those are the factors and the benefits that we see. Of course, empathy being the center point, because now employers do understand that people have people to take care of who are highly exposed to these certain times, and that is something that now they are considering to an extent. And while they consider this, it's not only because they're becoming employee friendly, but they're also making sure that there is an enterprise risk which gets mitigated at a certain level. Because we know none of the organizations, and you talk about calling people back to work, the first question is, what if 200 people working 100 from my organization get infected? That is another risk that they're trying to mitigate while they structure a return to work, while they structure work from home. So I think it's a brilliant move how we see it, and a great, I would say, innovation plus we're seeing a shift. Both.
So I'll take a minute here and pose a query which has been posted by Mr. Sanjay Kumar, and it's a very interesting query, and Alpa, I'll let you address that, and then I'm going to get a quick view from Namrata, you as well on that. He's asking if there has been anything in the reforms that we're talking of to the labor laws, which will enable bringing in more women into the workforce.
I think that
in terms of security, in terms of benefits, in terms of anything that sort of incentivizes more women to be a part of the workforce.
Sure. I think, Lakshya, I would say that, those are more...
Sorry, that question was from Mr. Ramesh Kumar. My apologies for addressing that as a question from Mr. Sanjay Kumar.
Sure. So basically, I think those will be more governed from the rules that the states will have. Because when we see the night shift arrangements, the labor laws will definitely enable, but the states will have to take a stronger and a more stringent action when it comes to putting it on paper and enabling more women employees to be present at workforce.
Namrata, you have any quick thoughts on that?
Sorry, can you, I'm sorry, I missed it, sorry.
So the question is there any specific welfare and social security legislation in the new labor code to attract more women and provide more security and safety at work?
Well, I can give you a very quick example of state of Karnataka, which has recently permitted women to work at night. You have to obtain consent of women, and employer has to ensure that she's safely picked up and safely dropped. So earlier this permission wasn't in place, but now recently Karnataka has kind of making it in sync with the labor codes that are going to come into play very soon. Another thing which is very good about these labor code is equal opportunity for women and ensuring the safety and security within the codes itself. And Karnataka is one such example. State of Tamil Nadu will be rolling it out very soon, allowing women to work at night. However, employees there, it is subject to certain conditions, and one condition being very critical, that you have to obtain prior consent of the women.
Thank you. There is a very interesting example that has been quoted, on the platform, and I would pose that to all of the panelists here, and then maybe we can all sort of give one pointer each in terms of what are our thoughts on it. So Mr. Chandrasekhar Prabhudesai on the platform is saying that office in charge was taken, I think this is officer in charge was taken by signing contract in year 2011. Contract was not renewed after expiry. I'm not still very clear about the facts, Mr. Chandrasekhar. So if you would like to come online and pose this question, it will still be good. I think he has a very specific query where the staff was terminated without any reason. And he wants to know how, in context of the new labor rules, this will be seen, and if at all this is still permissible or this could be allowed under the new codes. I'm not sure if you're live, but if you are, kindly unmute yourself, raise your hand, and we'll pick up your question. Because the facts are not very clear. I think the panelists are reading those, but the specific facts need to be known for what has really happened. The generic question is, are the new labor rules applicable to staff? And is the staff benefiting, or is the staff at loss because of this? Naveen, would you like to take that, and then we can...
Can I take that?
Yes, Danny, sure.
Yeah.
Yes.
So there is no need to panic in terms of termination at will. So the changes have not really impacted that, right? And if you see the ground of termination mostly are covered in the shops and commercial establishment, which are the state subject, which means you cannot terminate somebody without reason. But if they have to terminate somebody without any reason, it comes under retrenchment. And for retrenchment, there are notification, compensation to be paid, and I said reskilling also to be paid. So there is no such change that the court has introduced a fire at will. It is a term which has been loosely thrown around by trade unions. No such change have drastically come. Obviously, all companies and most companies do have their service rules. Yes, the only sort of concern I had was the applicability of the standing orders. It should have been made applicable to most companies, so that employees have that sort of assurance that we have a service rule which I can read and quote and say that these are the rules which are not followed in line with my termination.
Sure. Thanks. There is another interesting question which has just popped up. I think somebody just reflected my own thoughts. So the question is, with the new labor codes in place, how mandatory it is to have equal opportunity, equal pay policy. And if a parent company has such a policy, is it required for the Indian subsidiary also to either reflect the same or have a separate policy in India? Panelists, anyone who can take this? this is something which most of us would like to
No,
know.
equal pay is more about not, discriminating in terms of payment to different sexes. So it's
I
not
think
about, yeah.
what Mr. Lakshmi Naik is asking here is not with respect to discrimination. He wants to understand that if there is something
Yeah. So I got it,
existing.
Laksita. I got it, Laksita. So what I'm saying is the laws are regarding discrimination on that ground. Just because you're a lady, you have same competency as me, but a company pays me more and pays you less when we're doing the same job. So I think the law is only concerned with that, right? It's not concerned about A company, B company, who's paying more, who's paying less. That the only thing they have done is about minimum wages, which the central has also fixed a minimum wage, which the states have to abide with. They can pay more than that. I think in terms of salary, those are the only changes they've made. And I don't think the central can really tell us what is the salary to be paid by private companies, especially.
Thanks, Danny. I think his question was not so much on just the Indian environment, and therefore my answer to that is if the question and this is for the audience, if the question wanted to pose more with respect to parity between the salaries paid at headquarters, which may be outside India, and sort of corresponding salaries in India. I don't think so. That is a question for labor laws to address, because labor laws are territorial in nature. Those are only for the country that they're designed to. Within that territory, there will be parity. And as Danny already mentioned, there is equal pay, equal policy that exists. And the laws apparently address that to a very large and satisfactory extent.
Right. Supreme Court judgments actually will form a more basic ground to get to understand more details of the subject, rather the labor code itself.
Sure. Sure. Is there any other question that we would like to take from, if any of you panelists are looking at questions right now on the board?
Lakshika, I have kind of answered reply. I've been typing the reply and answering some of them.
Yes,
those specifically posed to
and
me.
Also, there is someone who begged to differ with your answer earlier.
I gave him the answer.
Yes,
I gave him the answer.
Danny also covered it in his answer. So
Yeah,
there is
yeah.
a process for it of
Yeah,
how
absolutely,
it happen
absolutely.
and stuff like that. I think Namrata answered it in short, so she had to be brief, and she just mentioned that it has to be as per process. She didn't mean that it is or it is not possible. So
yeah. I've already written. I've given my answer.
So I don't see any new questions right now. But
it's one is on POSH. If we want to take POSH, I can answer that question.
Yes, sure, absolutely.
Yeah. So the question is, it's not question, it's just a comment, which I kind of really appreciate. Just give me a second. It's from, I promised him that I'm going to take it live. I'm not able to track it. It's not coming on my chat. Basically about, can you please throw some more light on work from home in POSH?
Yeah.
So which I thought was very interesting. Well, I wanted to actually talk about it, given the fact that in 2018, we went a little kind of berserk, saying that there was a increase of 14%, of POSH complaints. And you'll be quite surprised that this year, despite having lockdown, we are all working from home, and we think it's a safe environment for women. Safety is being followed. There's 20% increase, by the way, since 2019 and 2020. And more so, Lakshika, I think you see, there have been instances. Even during the lockdown, there have been instances where women have kind of complained that their bosses or their seniors or their colleagues are not respecting the fact that we have to follow company policy, company procedures, timelines, working hours, and any call beyond the working hours, or suggesting a call beyond working hours, and or forcing someone or a woman to switch on the video, come close, or I can't see you better, or passing these kind of remarks may kind of fluster someone. and also WhatsApp messaging, where there were physical compliments. Now those compliments are coming through WhatsApp message. So sometimes there are you wanted to say something? You wanted to
No,
add?
so I think, Namrata, I totally agree with that point, because earlier when women went to work, that is the place where they're working, and that is a confined premise.
Absolutely.
Where they're working under a certain discipline or guidance or governance and watch of the organization. Now
Absolutely.
what has happened is all of us are working from home. So our managers, our supervisors, everything, when you talk to them, when you call them, when you have a video call, even this conference has literally come to my sort of, if not my bedroom, definitely my living room. Everything, everyone
Very
has
true.
literally now got access to my living room, and they have access to the environment that is extremely personal to me, right? It could be my children
Very true.
in the
Very true.
background, or my help doing something, or something else, my in-laws working around somewhere, or there are conversations, there could be relatives in the background. So I think the kind of problems are far larger now, and there needs to be a very different kind of sensitivity. I think it will depend a lot on how now organizations retrain their people on understanding what these sensitivities are. All that happened earlier is now talk of the past, because
Absolutely.
the times we are living in now requires a very different level of understanding of what could constitute that kind of infringement of someone's privacy, infringement of someone's or making someone uncomfortable. Those boundaries, those parameters, everything has changed now.
So I think what employees need to respect is that they are still very much they fall under the under their current policies and procedures that have been put in place, and they have to follow them, whether they are working from home. Each and every policy of the company or the procedure that have been laid down internally, the standard operating procedure, they have to follow. They have to follow it. They don't have any other choice, because they will be in breach otherwise. We were really kind of not prepared to have meetings while while live on camera. So there have been instances where supposedly we all are talking right now, and I can kind of take a screenshot of it and start floating it on social media without taking your permission. That might make you uncomfortable. You might not be properly dressed. We are just having a normal conversation about about something cropping up in any business deal or something like that internally, and you might just click my picture and put it on social media. I might not be appropriately dressed. That's not that's not right. So that is the reason why lot of employers are re-looking at their POSH policy, because POSH was basically with the intent that first Vishakha guidelines came, and suddenly POSH rolled out, and suddenly under POSH you were mandated to have conferences. You had to make your own employees aware about all these things. There are obligations on employers, and everything was hastily done, and people just kind of created this policy, and there were complaints, and some of the companies are handling it very well. But despite that, they were not prepared that there will be a time when they will be holding virtual POSH or handling virtual POSH complaints. So I think you need to, as an employer, you need to re-look at your policy. And if there is a facility of video conferencing, although whenever I draft, I always put video conferencing within the POSH policy to make sure that whether or not you have a complaint from any of your employee, you must hold, as an IC committee member, you must hold from time to time create awareness among your IC committee members, also training for your employees, so they are a little more, they're sensitized toward certain things that they're not supposed to speak just because they are, talking informally. So they don't think.
Just to share a personal experience here, Namrata, during these lockdown times when everyone's working from home, we had to quickly roll out a new policy. And we have a process where all employees every 6 months take a test on that policy, and they have to mandatorily pass that test. So immediately after we rolled out the new policy, because it has new guidelines, new examples, new instances that are being quoted, and a different questionnaire to sensitize people, we asked everybody to sort of then submit and clear that policy benchmark or that bar needs to be cleared, and we gave everyone a deadline for that. Otherwise, you're right. We were coming across a lot of issues. Thankfully, there were no complaints, but I think the working hours have stretched almost 24/7, more so for women, because sometimes, you know, I have a young lady in my team who has a 1-year-old daughter. And even though we may be on a global call, if her child is running around and falls down, she has to hang up on the call and run and look after her daughter. So, you know, all of these things have to be kept in mind. And just because a supervisor is not sensitive to these issues, there shouldn't be anything that impacts that lady because of that. So I mean, very good points there. Alpa, do you have any quick comments there which you can share as a personal experience on this?
Sure. I think, Laksika, one of the things about video conferencing and the cybersecurity space that we're talking about from a posh aspect or a general, while we talk about employee security in terms of while we are in this virtual environment, I think the one example that I have, which is from my personal experience, is a very initial stage when we just started. I believe it was the end of March, we started work from home. I had personally had Brad Pitt coming to my conversation with me and my boss on a video conference. This is the level of encryption that we had in the initial when we started our virtual world and we started working from home. This is the cybersecurity that we're talking about. And that was actually a test run by IT. And they said this has actually happened in multiple organizations. We wanted to see how sound it is to, you know, experiment it or not, you know, go ahead with this at a larger level. So, and
is it Brad Pitt peeping around all the time, or are there Tom Cruise also doing rounds?
Yeah, but I would like to add something, Lakshika, is very important. Like, you know, going forward, when you, you know, we are very, you know, we are not certain when the office is going to, you know, start, when we are going to physically go and use the office. I think if we are going to be in the virtual world, it's very important to relook at your POSH policy. Make sure that if you are handling any kind of POSH complaint, your witnesses, the complainant as well as the respondent, they're all very well aware. There cannot be any deviation from the procedure laid down under the Act. You have to strictly still follow the procedure. There cannot be any variation or deviation. What you can do is when you're, especially when if any evidence is being submitted to you, so what you can do is you have to equip your organization to make sure that they are digitally signed by the complainant and respondent. And the files that you're sharing should be encrypted. And there should be only one person who should be handling the entire data, since confidentiality or breach of confidentiality has consequences under the Act.
It's a big issue.
So
yes.
Yeah, it's a very big issue. And so I think, you know, when you're virtually handling, I think the sensitivity all across the board is very, very important. So you need to make aware the parties concerned and whatever you are kind of exchanging the documents, because there might be some CCTV image or there might be some
and even
evidence.
the platforms need to be secure. People have this
Absolutely.
habit of WhatsApping everything to everyone, you
Absolutely.
know, or just keeping things in their phone and then it goes all over. So that is something which is a big, big red flag for such things.
Yes, very much true. Yeah,
I mean, unfortunately, panelists, I know this is so engaging. I don't want to sign off, but I think I'm getting a nudge from Samriddhi, and she'll have to stay on till the time we don't wrap this up. So we will have to unfortunately wrap it up quickly. There is still one more unanswered question, but if I can request one of you to answer that on the platform itself from Mr. Ashish. You know, this is on statutory bonus under the new codes, and if you can, one of you, Danny, Naveen, Namrita, or Alpa, take it, or if all of you can give your thoughts on this question, it'll be great. With that, thank you so much for being such a wonderful panel. I didn't know that there was so many interesting aspects to labor codes. I mean, it's a whole new world, and I think we'll get to see more excitement as we go along. Thanks so much, Samriddhi. With that, I'll hand it over to you. Thank you. Thanks, Lex Witness, for having us here today. Thank you all. Thanks, audience, for being so patient.
Thank you all.
Well,
Thank you so much, Lakshika. It was great. Great to be part of this panel, and I was excited to share my thoughts, and I'm really very happy to hear everybody. And Danny, Alpa, you, Naveen, everybody did a great job. I mean, it was very informative for me per se as a panelist. Also, I learned so much today. So I think I hope it was great for all the audiences.
Same here, Lakshika. That was really great. Nice to hear you all.
Thank you everyone.
Thank you everyone.
And we'd also like to thank all of our participants for logging in and staying back till the end. Of course, we don't have a lucky draw or any mementos to give like the in-ground events, but we wish you all safety and health and a very long life. So we see you all once again very soon on our on-ground events. So thank you once again for joining us. Everybody, let me very quickly run you through tomorrow's agenda. We are going to start at sharp 11 a.m. And we have a session on e-contracting today and tomorrow, geared up. That's a panel discussion, followed by a focused presentation on India's road to digital tax. And lastly, we'll be having another panel discussion on e-commerce, a heavier cart now. So we hope to have all of you once again with us tomorrow. And we thank you now. That's all we had for you in this webinar. Please stay with us tomorrow too. Join us tomorrow at 11 a.m. And we're now going to end the webinar. Thank you.
Thank you.
Thank you.
Thank you, everybody. Bye-bye.